the score sheet, the defense not objecting?
No objection to the score sheet, and will stipulate to a factual basis for the purpose of the plea and are unaware of any DNA evidence that exonerates Ms. Acevedo.
Very good. So, I'm going to mispronounce your last name, Acevedo?
Acevedo.
Okay, Acevedo. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
You heard your attorney state the terms of your plea agreement. You can put your hand down.
Yes, sir.
Is that your understanding of what the plea agreement is?
Yes, sir.
And you understand that by entering into this plea agreement, you're waiving a number of rights. The most important right is the right to contest this, to go to a trial, to call witnesses. Do you understand you're waiving those valuable rights by entering into this plea agreement?
Yes, sir.
And you understand that this will be a final resolution of this case, okay?
Yes, sir.
Barring some kind of unusual thing, it would be difficult to appeal it, et cetera. Have you gone over all these, asked kind of these type of legal questions with your attorney, make sure you understand
Yes, sir.
what you're doing legally, what the legal implications are? Just want to make sure you understand what you're doing it freely and voluntarily.
Yes, sir.
Anybody promise you anything or threaten you to get you to enter into this? This plea is entered into freely and voluntarily?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea as stated by by the defense counsel. Most important is the withhold of adjudication and 2 years of probation. On each count, they'll be served concurrently at the same time, so it's a total of 2 years probation. Very good. And as well as the other costs and fees that are contained in the plea and sentencing agreement, which I see you've signed at the back here. Oh, but we didn't have Mr. Keach sign it. See, we always have to look at these things. So you went over this plea agreement with your attorney, the details of it? Okay. Thanks. Okay. Thank you, ma'am.
Thank you.
And Your Honor, I think Mr. Keach said he was appointed on this.
It's included.
Yes.
Okay, and we ask the supervision fees be waived based on this.
Supervision fees will be waived. Yeah, she resides in Orange County. Do we have to do anything?
We'll transfer her down there.
Okay, very good. John Davis.
Your Honor, I believe Mr. Davis is outside having his cheeks swabbed. Oh, is he back? Okay, there he is.
Yeah, please, the court, Your Honor, Brad Stewart. I'm covering for Mr. Powell, Judge. Mr. Davis is present. We were present before the court with regards for Mr. Davis to provide a buccal swab, which was done. I did want Mr. Davis to remain so the court could see, lay eyes on him and see he has appeared and has complied.
Very good. So when is our next scheduled hearing? Are we scheduled up on the August 22nd pretrial?
We haven't been, but we would like to at this time.
The court will come back on our normal pretrial on our next cycle on August 22nd at 9 a.m.
Very good.
Okay. Thank you very much. I think that's your only one, isn't it? You have a couple
No, Your
others?
Honor, I have one other matter on the docket.
Who-
Gunter, Jeffrey Gunter. He's an inmate.
Okay, let's go ahead and bring out Mr. Gunner and Mr. Stewart.
Your Honor, if I can pause for a moment as Mr. Gunter signs a previously reviewed plea and sentencing agreement. Credit time served. This change for the date of birth. I had to change it. 6 there. Curfew I had backwards, had 10 a.m., 6 p.m.
Right.
I had to change it 10 p.m. to 6 p.m.
You grab
a.m.
it through me.
Yeah. All right, you good?
One question, if he does allow me to stay, bring an agreement so I can send him.
Yeah, it'll be in the court. It'll be in
The agreement says I get the pin, right? Thank you, Brian.
Your Honor, I do have an executed plea and sentencing agreement with a score sheet. May I approach?
Thank you.
This time, Mr. Gunter is prepared to tender a plea of no contest in case numbers, and for the record, Brad Stewart on behalf of Jeffrey Gunter, Judge, in case numbers 20 CF 538 and 21 CF 800. Your Honor, the agreement calls for in 20 CF 538, counts 1 through 3, he'll be sentenced to time served. That's a total of 471 days. Court costs and ability to pay during probation period in 21 CF 800. In that case, it will be adjudication, 24 months Department of Corrections with special conditions as announced therein, Judge. We are requesting to waive cost of supervision, and we do
Go over
have...
those special conditions just to make sure that everybody's in agreement on it.
Yes, Your Honor.
Either you have to announce it or I do, so
I'll be happy to announce it, Judge. 24 months Department of Corrections, Judge, and that'll be concurrent, of course, with 20 CF 538. Got that case number, 538. Credit for all time served, followed by 10 years of sex offender supervision, Judge. Appropriate fines and court costs, 515 plus 151, and $150 public assistance fee. While on supervision, Judge, he will be required to have the GPS monitor. I would request the court assess that at $1 per day with the sex offender designation. No contact with the victim, ST, date of birth 11/02/2016, or 2006, excuse me, whose guardian is Donna Carson. No unsupervised contact with minors. Contact with the defendant's biological child is allowed if agreed upon by the other biological parent. Is forfeit seized devices any statutory requirement for sexual offender designation to include counseling and treatment. Curfew of 10 p.m. to 10 a.m. as adjustable for work purposes. No internet-capable devices until sex offender treatment is completed. Count 2 shall be dismissed. Judge, we are also...
count 2 in case number 21 CF 800.
That's correct.
Okay.
Judge, as it relates to the remaining approximately 7 months still outstanding on the 24-month sentence, we are requesting the court will allow Mr. Gunter to finish out that remaining 7 months in the Okaloosa County Jail as opposed to transport to DOC, given the short length of time. I don't believe that the state has any objection to that. Court's discretion.
That's correct, Your Honor. We defer to the court.
Gunter, would you raise your right hand?
Sorry, dude.
Swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, yes, sir.
State's in agreement on this.
Yes, Your Honor, and for the record, this is a downward departure based on a negotiated plea.
Ladies and gentlemen, please make sure if you have any electronic devices that they're on silent or off. Repeated activations will be subject to a confiscation of your device.
And the defense is not objecting to the score sheet.
No objections, deletions, or additions. We're unaware of any DNA that is not disclosed or
Is
exonerated.
the defense agreeing that there's a factual basis for this?
So stipulated for purposes of the plea, Your Honor.
Mr. Gunner, you just heard your attorney state the terms of your plea agreement.
Sorry,
Is that your understanding of the plea agreement?
100, yes, sir.
And I see that you've signed what appears to be your signature on the plea and sentencing agreement that contains that and some additional details as well.
Yes, sir.
Is that your signature, and have you gone over this in detail with your attorney to make sure you understand all
Yes, sir.
the legal ramifications of this?
Yes, sir.
You understand you're waiving a number of rights by entering into this, most important of which is to go to a trial and to contest all this, right to confront witnesses, et cetera.
Yes, sir.
You understand that? You understand that by entering this, you limit your ability to be able to appeal it later?
Yes, sir.
Okay. And you have not been promised anything or coerced to enter into this plea?
No, sir.
You're entering this freely and voluntarily.
Sir.
Are you satisfied with the representation you've had from your attorney on this?
Yes, sir, I am.
Okay, based upon that testimony, the court will accept your plea agreement and will sentence you as stated with specificity in the plea and sentencing agreement, the core of which is the 24 months in the Department of Corrections, concurrent with 2020 CF 800, credit for time served, which has been identified or specified as 471 days. And the court, as well as the other issues that are contained in more specifics in the plea and sentencing agreement. Court's going to order him to serve the remainder of his time in DOC, not in the county jail. Thank you very much.
Does the court have any objection to waiving the cost of supervision based on the length of incarceration and length of probation that he has to undergo after?
Court will waive cost of supervision.
And will the court recommend he be housed in a local facility as well? He does have family in the local area.
Any objection?
No, Your Honor.
Without objection, the court will grant that.
Thank you, Your Honor.
Probation?
And Your Honor, I know Mr. Stewart brought it up, but I'm just making sure the court is going to grant probation the ability to adjust the curfew as we see fit.
I appreciate you clarifying that, and the court will grant that to make sure you have, we're not trying to interfere with your work schedule, but there are a number of details, obviously, on the community control and that are going to be important for you to follow in detail. Did I say community?
Probation.
Probation.
Yes, Your Honor.
But specified areas in probation that are unique to probation. Okay.
And for the record, we would announce a formal dismissal of count 2 in 21 CF 800.
So noted. Okay, thank you very much.
Thank you, Your Honor. That's all I have. May I be excused?
You may.
Thank you, Your Honor.
Derek McKinney.
Good morning, Your Honor. Jack Wilkins for Mr. McKinney. May we approach briefly, Your Honor?
Sure. This case will be continued for the standard pretrial on August 22nd at 9 a.m.
Thank you, Your Honor. May be excused.
Thank you.
Yes, sir.
And we've got one inmate that I show does not have an attorney. Why don't we go ahead and give him so they can take him back? James Mattingly. Good morning, Mr. Mattingly.
Good morning, Your Honor.
You're here on case number 2019 CF 1468. This is a violation of probation. You didn't hear my opening remarks, but because you don't have an attorney, this is kind of like an arraignment today, where you have a plea. Because you don't have an attorney and haven't had an opportunity to consult an attorney, I want to ask you, first of all, do you wish to have an attorney appointed?
No, not for a violation, Your Honor. I've got enough time in on this charge so I do believe I've already got time served, I hope.
State's offer is 9 months in jail, credit for the VOP time only, and revoke and terminate the probation.
Approximately, when did that start?
I think the warrant was served June 18th
Of,
this year.
okay, so let me make a suggestion. You're generally not in a good posture when you don't have an attorney operating against an attorney. So I'm going to enter a denial on your part, so your rights aren't prejudiced. I really urge you to accept the appointment of an attorney. Talk about what you think your posture is, because I think it's a little different than what the state's position is. It's not going to hurt you by doing this.
Will I have to stay in jail for another month or something like that?
Right? I mean,
I've already got the time,
you're not going to be getting out based on the offer the state just gave you. Right, counsel?
That's correct.
Not even close.
Okay, she said time served. I've got 16 months in on this case.
Your Honor, I would ask if we could just appoint the public defender, or I think he was previously appointed to RCC. He has been to the Florida State Hospital on the underlying before, although he was deemed competent at some time, but we could just have an attorney.
So I'm going to go ahead and appoint counsel. Maybe even if we have a chance to chat with him even this morning and explain to him whatever. But if not, be able to meet up with him and.
That'll be fine, Judge. If you want to have him, hold him back in the back, and I'll come back there and talk to you.
Yes.
Explain everything to you, and then if
Okay.
we can resolve it,
Perfect.
great, and if we can't, we can't.
I'm hoping
Okay.
it's resolved today. Thank you.
Okay, thank you. Mr. Tony, I want to start with Bryant Pate.
In regards to Mr. Pate, Your Honor, we hadn't had an opportunity to resolve this matter. I talked to the state yesterday, and there's an outstanding witness that needs to be deposed. However, that witness is currently in the county jail, and we had to work through his public defender to get him permission to talk to him to set that deposition.
Okay, so
So
we
I think that's probably going to go past August.
our next cycle.
Yes, unfortunately.
Why don't we do this? Why don't we, obviously, our next pretrial is just, a couple weeks away. Well, it's 3 weeks. If you don't think you can get it resolved before then, you want to just go ahead and set it just to keep track of it, or if you don't, you're absolutely sure you can't, we'll roll up to October 24th with the understanding that if you get it resolved, you can put it on a miscellaneous docket and plea it out.
That's fine.
You want to do that?
So that would be the 24th?
October 24th, 10/24, 9 a.m. Okay, Mary Lou Thornton.
Yes, Your Honor, and with regards to Ms. Thornton, I've talked to the state today. We're in discussions of trying to bring this thing in. There's a discussion that I think they want to have with the victim prior to, and so I guess we're just going to have to continue that one to the next cycle as well.
Well, let's come back on our regular cycle on August 22nd at 9 o'clock.
Okay, that's all I have. May I be excused, Judge?
You may.
Thank you, sir.
That's all I've got. Any other private counsel? I think that's it. Ms. Flowers? We'll go ahead and do the regional conflict, and then we'll do the people that don't have attorneys after that. So let's begin with Lena Creech. I believe she's an inmate.
For the record, Your Honor, Jennifer Flowers on behalf of Lana Shaw Creech in 21 CF 2735. Ms. Creech is here. She is incarcerated and awaiting transport, I think, to Florida State Hospital. We put her on today's docket for a status conference, which I'm glad we did. It appears she has not yet been transferred. I'm going to get in touch with who I need to get in touch with at the courthouse to get her transported as soon as possible. So I would ask that we put her on for the next available miscellaneous date.
8/4?
On the 4th to confirm that she gets transported.
Continue 8/4. If there's anything that I can do, any orders, anything, you just let me know.
Thank you, Judge. Thank you.
Standing by.
Okay, okay. Thank you, Your Honor.
Thank you very much.
Thank you. We're going to bring you back on August.
Thank you. Marquise
Okay.
Demons? Not sure. How do you pronounce that? Demons?
Demons, I believe it's Marcus Demons, Your Honor. Good morning, Your Honor. Jennifer Flowers on behalf of Marcus Demons in case number 22 CF 1469. We're here today on a motion to set bond in his case. Your Honor, the defense is asking that based on, Mr. Demons was arrested back on May 28th, 2022, and has been, at first appearance, was held with no bond in this matter. The state has not yet filed a formal charging document, and information has not been filed in the case, and he's been incarcerated over the 40-day max. So pursuant to, and I have a copy of the rule for the court, if I may approach.
Sure, sure.
Florida Rule of Criminal Procedure 3.134, we're asking that the court release Mr. Demons on his own recognizance. As the rule states, he's been in custody more than 40 days with no formal charging document, and the rule requires, as I read it, that the court shall release him on his own recognizance. So we're asking that be done today.
Normally, when we come up for arraignment, and the charging documents haven't been filed, we put it on a short, kind of a short leash and come back on that. Did we not do that on this? I'm surprised that we're here, you know, what, May, June, July, over 2 months, 60 days? Maybe I'm miscounting, but it's unusual to
I
have
think
this time.
what happened was a written plea of not guilty was previously filed by the Public Defender's Office. So that may be, and it just got set for pretrial. And then I think Ms. Flowers got assigned.
Filed the formal plea because there wasn't an information filed. So that
Right.
kind of confused everything. That's all right. No, I'm
Yeah,
not,
right.
if nobody
And,
did
Your
anything, I'm
Honor,
not.
actually, when I set this motion for bond, I filed it back at the beginning of July and just realized yesterday how long he had been
Right.
incarcerated, because I was confused as to why he was held with no bond on these charges, particularly at first appearance. So it was a confusing case to me. But, you know.
So let's just as to the argument for the defense, and any,
Judge,
Seems
the
to
bond
be pretty-
motion was not filed under that rule, but I am very familiar with that rule. We are still waiting on other evidence to be tested, phones to be downloaded. I do concede that he has been in for the amount of time stated.
you
So
know,
at this point,
disagree as
that's...
to the workings of the rule that she cited?
Oh, no, Judge, that's correct. I'm very familiar with that, so I would
Or grant the
stipulate.
defense's request and release the defendant on an ROR bond?
Thank you, Your Honor.
You'll be able to get out immediately, but you do need to stay in touch with your attorney. When is the next court date for this defendant?
It's set on the 22nd.
Okay. So the regular pretrial on August 22nd.
If we need to keep it on that, Judge, because an information hasn't been filed, so do we need to put it on a potential arraignment, a plea day?
Yeah, that probably,
Instead,
when do you, I mean, you have any sense?
waiting on phone downloads, Judge, I'm at the mercy of FDLE.
Okay.
I have 175 days, so if we want to set it on another plea day, the one after August 4th, maybe?
August 25th?
That'll work.
Okay, so August 25th at 9 a.m.
Okay, so we're not going to put him on the pretrial docket on the 22nd?
Right.
At 1:30, excuse me, not at 9 a.m., 1:30 p.m. And we will not have him, he's not on the 22nd. Okay, that's substituting.
Thank you. All right, thank you, Your Honor.
Okay, thank you very much. Hopkins, Stephen Hopkins. You want this back?
Oh, it's an extra copy for the court. This is the agreement for credit for time served. I'm just going to give you a sign. And Your Honor, if I could just have a moment to have Mr. Hopkins sign a previously discussed agreement. I don't believe so, no. Yes. Go against your license, though. I am now signing it. Apologize, Your Honor. And actually, I have to get the state sign here.
There's the score sheets right there.
Thank you.
Your Honor, this is Mr. Stephen Hopkins. We're here in case number 22 CF 1322. We've reached an agreement with the state. Mr. Hopkins is going to be entering a plea of no contest as charged in the information. The terms of the plea would be an adjudication of guilt, credit for time served, $515 in court costs, $100 cost of prosecution, $150 cost of defense, and that money to be paid to the clerk of court within 180 days and then to collections.
Good, and the defense is okay with the score sheet?
Yes, Your Honor.
Is the state in agreement?
Yes, Your Honor.
So, Mr. Hopkins, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, speak up, because
Yes, sir.
we can do it. You heard your attorney state the terms of the plea agreement. Is that your understanding?
Yes, sir.
I see you've signed the plea and sentencing agreement. Have you gone over this with your attorney? Make sure you understand. Obviously, it's a good deal. You're getting credit for time served. You're not going to have to serve any additional time, but it does impact your record, and there are fees and costs. Have you gone over all this with
Yes,
your
sir.
attorney to make sure you understand legally what you're doing?
Yes, sir.
Because you are waiving the right to go to a trial and to contest all this. You believe it's in your best interest to enter into this
Absolutely,
plea
yes, sir.
agreement? Okay. Based upon that information, the testimony of the court will accept your plea agreement. There'll be an adjudication of guilt and the credit for time served and the court cost and fees that are contained in the plea agreement to be paid within 180 days, then it'll go to collections. Okay? Anything else?
That's it. Thank you, Judge.
Thank you. Tatum, Lamarcus Tatum.
Yes, Your Honor, for the record, this is Mr. Lamarcus Tatum. We're here on a violation of probation in case number 20 CF 2382. Your Honor, today, Mr. Tatum wishes to admit the violation. The terms would be an adjudication of guilt, will reinstate probation to the original term, reimpose all prior terms and conditions, modify only to include 100 hours of community service work. He'll have to pay the $100 cost of prosecution, VOP fee, and $150 cost of defense.
The 100 hours, is that,
Additional.
were there not any community hours before, or there are 100 more hours?
100
I'm
more
trying to
hours.
be clarified.
100 more hours. I'm not sure if there were any on the original agreement. I don't believe so, so this is an additional 100 hours.
Okay, thank you.
May I approach with the plea?
Is that the state's in agreement?
It is, Your Honor, and I'd like to commend the defendant for getting a valid driver's license. That was the reason he violated, and it took him a little while, but he did get that license
Okay.
validated.
Very good. So, Mr. Tatum, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
And I see you've signed the plea and sentencing agreement. Have you gone over this with your attorney? Obviously, you can put your hand down. Obviously, it's a good agreement. You're just being placed back on probation. The only real addition is the 100 hours of community service, and you're reinstating probation with the original terms. So you got to make sure and continue to coordinate closely with the probation office so you can get through this. 100 additional hours of community service. You understand that's the main additional factor here? Okay. You understand you're waiving the right to contest all this, and this is the final resolution of this matter? Okay, very good. Based upon that testimony, court will accept your plea agreement and reinstate probation on original terms, reimpose, prior terms and conditions with the single addition of 100 additional hours of community service. Okay? Good luck. Thank you. Does he need to be in touch with you? Okay, come on. Okay, I think you're good.
That's all I
Okay.
have this morning. I'll be back this afternoon if I need
Okay,
the
thank
excuse
you.
till then. Thank you.
Okay, so what we'll do is, we've got a few that are no attorneys. We'll take a short break, a morning break, and then we'll come back and hit the PD files. Okay, so don't believe any of the no attorneys are in jail. Richard Anderson. So if the state will help me out on this, you just come up to the podium, sir.
20 CF 3115.
We're here on a violation of probation, correct?
That's it, Your Honor.
Okay. And you heard my earlier statement, Mr. Anderson, you do have a right to an attorney. Do you wish to have an attorney appointed? Court will appoint the public defender, and the court's going to enter a denial, which is the same as not guilty for a violation. Denial will come back. When are we coming back on this?
Could we make
Come
it
back,
8:25? That would give us a little bit more time to maybe meet
Yes.
with Mr. Anderson.
come back on, is that good?
Yes, Your Honor.
Come back at 8:25 without subpoenas in the morning, so 9 a.m. Just make sure and be in touch with your attorney, okay? Mr. Brown, Robert Brown. The state announce, please.
Yes, Your Honor. That is Robert Darrell Brown, 16 CF 1057. This would be his third violation of probation. The state would recommend he get an attorney.
Okay. So, Mr. Brown, again, you do have a right to an attorney. You wish to have an attorney appointed? Yes. The court will appoint the public defender, and the court's going to issue a denial, so you have a chance to meet with your attorney. We'll come back on 8:25 without subpoenas at 9 a.m.
Thank you, Judge.
Okay. Kent Flowers. State announce, please.
Your Honor, Mr. Flowers is before the court on 20 CF 268 for violation of probation.
Mr. Flowers, as you've heard me state, you wish to have an attorney appointed?
Yes, sir.
The court will appoint the public defender. The court will issue a denial so you can preserve your rights, and we'll come back on 8:25 at 9 a.m. Make sure and be in touch with your attorney in the interim,
Yes, sir.
okay? Figure out what's going on here.
Thank you.
Okay. Philip Nance.
Judge, this is 21 CF 2659. Nance is here for his second violation of probation.
Mr. Nance, you do have a right to an attorney. You wish to have an attorney appointed. Court will appoint the public defender. Court's going to issue a denial. We'll come back on 8:25 at 9 a.m. Make sure and meet with your attorney in the interim
And that's without subpoenas, Judge.
without subpoenas. Brian Reed.
20 CF 3167. Mr. Reed's here for his first violation of probation.
And Mr. Reed, you do have a right to an attorney. As we stated, you wish to have an attorney appointed.
No, sir. I finished my the anger management. Mr. Edgar.
Hold on a second.
Did I hear you say you've completed anger management? Do you have proof of that?
He's supposed to send it. Mr. Edgar at Patterson. He's supposed to send it to James Morgan.
Have you paid your monies?
That's the only thing. I'm limited funds.
Your Honor, I'm sorry, I can check and see if he completed anger management.
Yeah, Judge, I'm inclined,
Patterson.
I have in my notes I was going to dismiss if the anger management was completed and the fines were paid, but if the fines are minimal or a lower amount, we might could send them to collections.
Give me a minute.
Yeah, let's just pass over your case, hang with us, and we'll come back. Okay. The court, before we take a break on this, the next case, Marina Strangeland. This is, if the public defender will make note of this, this is case number 21 CF 2562. It's a violation of probation. The underlying is driving on a suspended. They contacted our office. She is very sick. And so the court basically told her, I'm going to appoint a public defender. I'm going to enter a denial on her behalf. She was proactive in doing it, and she was quite obviously legitimately sick. So based on the type of charges, et cetera, I think it would be better. So we'll come back on 8:25 at 9 a.m.
Thank you, Judge.
So I think that's all of our no attorneys. So why don't we go ahead and use that as an opportunity to take a short break. We'll come back in 10 minutes and we'll begin we'll revisit the case, and then we'll come back with the public defender's cases. Okay?
All rise. You may be seated.
Actually, we've done that. I mean, it might be coming out of. I don't see that here.
Okay.
This is saying we're reinstating the
Oh.
But work that angle.
Okay.
We can get squared away.
You think? Okay.
Yeah.
Okay. I will do what I can.
He already did this. He did. He was fucking up. He wasn't doing that. This colloquially is a little. But we can get from here to the finish line. That's me and you.
Okay.
Okay.
Tag team.
On command control.
Okay.
And I will have no objection.
Right. Okay.
Not get out the door. That would And they're looking it up. Okay. All right.
Okay. Yeah, we're checking on it.
Okay, thank you.
It may not look like I'm doing anything, but I really am.
That's right.
You're always working.
Got my people working on it.
There you go.
There you go. Got to have
Hey, you know
people.
anything good about the person? Yeah. That's a hell of a. Oh, okay, well, that's,
You know who he is then?
he had Johnson.
Oh, okay. I didn't know. He.
Huh?
And that's fine, and I'm good. Without a violation. Without it. He said, I need to. Does that take care of my lunch? And she said, yeah. There you go. Done. That's kind of how. And then after a moment of thinking, he went, wait a minute.
Good idea.
And he tried to back out of it.
Wow.
You backed away. You've already refused and left.
Well, can you
And
still
you come
listen to
back,
this? I want her to hear
and you
this.
come back next week and go, oh, I was just joking. You know,
He
that-
did tell her.
So listen to what Beverly.
But you well know. So I would do a best.
You've done that
Without
before.
thinking, right. I think me and you've done that before. I've done it for 1 year. But anyway, but anyway.
Oh, this one. Oh, you told me about this one.
And she said, Since then, my uncle, he went, damn. So that's why we're.
All right, I'll give him a chance. Tell him he's going next time.
Right, I don't know. I don't know if that's what he's gonna tell you.
He does.
Okay. I think after.
Oh, yeah, Shoal River, the new Shoal River.
Right.
Yeah, yeah, I remember when you were there.
He does. He has $18 an hour
I
job.
didn't have a
I did know that. I got you to run there.
All right. I will give him a chance. 'Cause I was just like, hard violation. Yeah, you can go back.
Mine.
Oh my God, it's Tom. It's not gonna go.
Y'all got some more new people over there. I'm like, who is this?
I don't feel like that. Because
We have one leaving too.
Oh, yeah? Where's he going? Probably gonna be a cop.
We tried to do
I think it's more of a reaction.
Well, one was dismissed. But he doesn't talk. Nurses have to talk.
You're not taking pictures. I mean, I'm not being funny, like, he would
Yeah.
probably do very well there.
Well,
Because he's calming.
Well, and he could get more money there too.
Yes.
Oh.
But I mean, you know, he's got that calming, like, I'm not gonna say, this is what we're
Okay.
I know you told me that. I just wanted to-
As in.
Pam. Pam.
That's what. Oh, Pam.
These in his there. But I checked this. That was my reaction. And then like a week or two later, I see him at the store dressed up, doing exactly like Cam described. I want to be, just go be a cop. And then I've been using him.
He did.
They will not.
Oh, like he was doing?
Best and.
This was like, no.
I went to Mr. Because it doesn't. The shorts.
I'm sure he's. Is that gonna be the day you submit your
won't
retirement?
If they ever made him carry a firearm, he would need to retire.
Right, I can't see the shoot. I can't shoot number one. I can't see.
Yeah, you know, all their flip-flops with all the.
Yeah.
Talk about.
He tried
Just on the forehead and-
He tried to judge when Hey, I'm not sorry. Come here right now.
Do it for. They got buying for what we.
Yeah, I chatted with him. And
Bless his heart.
yeah, yeah.
They got a lot of space.
Yeah, he told me about that.
And honestly, that is how it went.
Go back. Done. It's like, okay, you can go on. But we're going to try.
Still get to weed it down a little bit.
And it took away from us now.
So be prepared next time to be here for a long time, because I just set at least 7 early plays and there's still more, so on top of whatever's there.
That's a good thing.
So.
I got several of them signed, I
They
think.
tried the matter just wanting to take care of it, but no one else could. The one instead.
One that I ever had a problem. Found the damn thing. Go to jail.
Right.
And I got to thinking.
You got something on it, yeah, probably.
You let me run to the.
Go to the court, dude.
I mean,
Just
fair's
go.
fair.
Yeah.
He wasn't
yeah.
prepared to go to jail that day. And he came back and
And
he
he
did a
did, he
sentence.
came back.
Oh, yeah, the one for the, yeah,
He did.
yeah.
He showed up.
I talked to him in the elevator too.
I
told
knew-
all
I knew
people
he'd
in the
show up.
elevator.
Well, he said he was gonna come back on the fifth and something. You don't say coming back the day after Fourth of July. It's not happening. No. Just go, I will, I promise. He needed to take it.
And I think he was, that's Rich, I think he's to come up next too.
Mm-hmm.
That makes sense,
They won't let me out.
Y'all's got the keys to it. They'll be gone when you get back.
That's right. We all know the drive anyway.
I know.
I had
All day long.
He wasn't driving. They were pulling him over.
Oh, I know who you're talking about now. I know who you're talking about. You done told me that too over in Walton County.
That whole family, it's, come on, people, like, and we'll pass them on. I'm not driving.
Yeah, I'm riding under the steering wheel.
Come on, you have a steering wheel in your hand. This isn't a, this
Or
isn't a
traveling.
public road. This is a. How many times you been on probation? Oh, don't drive. You're on condition. Don't drive.
Mhm. Well, I've represented him. Bless his heart, he can't. He can't. When he said, he told me about the charge, because the charge was over. Got any proof? Proof.
Proof thing, that's, trip you out every now and then. Ain't just gonna take more.
Do that, not this time.
Yeah.
One of my former clients in Escambia, I went to a Dollar Tree and saw him in Dollar Tree, like starting to put shit into his pants, and I was like, sir.
You know, to certain groups.
Mm-hmm.
And she was like,
I was like, serious. I was like, are you wanting to go back to prison? Is it worth it? I said, because that's what's going to happen right now. He's like, Miss Ethridge, how are you? And I'm like, yeah. I'm like, put it back now.
I don't do that. I don't like it out.
Oh, yeah, oh, yes,
Okay.
of course.
so I'm trying to help her.
Of course.
Sell her nerves.
We're at minute 17. There's no end in sight.
to go home on Friday.
But we already did.
Listen to the radio. Let the seat back.
I did not honk on.
Sit there and look
I
pretty.
did
That's
start
all you gotta do.
like.
Ladies and gentlemen, Judge Ketchell's and route back to the courtroom. Please make sure if you have any electronic devices that they're on silent or off.
One of the Langley boys like them in there.
Aaron, I haven't taken jail in no time.
All rise. Court's back in session.
Please be seated. Are we good with Mr. Reed? Do we need to, you want to do that? Mr. Reed, come forward.
Just had the file. Here it is. Recalling 20 CF 3167. Your Honor, I got confirmation from probation that he has completed his anger management classes. He does owe some money, but if we could just send those to collections, the state would be willing to revoke and terminate his probation at this time.
Very good. So the court will send the costs and fees that are remaining to collections. Okay? Good luck. Okay. So, Ms. Etheridge.
Yes, Your Honor.
We'll start with your Jennifer Albro.
May I just have one moment, Your Honor? She would like to accept the state's offer, Your Honor. Right here. Yeah, however you turn it.
You may. Thank you. Would you go ahead and announce it for us?
Yes, Your Honor. Ms. Albro would like to enter a no contest plea and accept the state's offer. It would be adjudication of guilt, reinstate probation, and modify to 1 year of community control.
This is a VOP, so are we?
Yes. I'm sorry, she admit to the allegations in the affidavit.
Okay,
I
good.
apologize.
Okay, thank you.
Accept the state's offer, and it would be reinstate probation, modify to 1 year of community control, the same terms and conditions, and there'd be an additional $100 cost of prosecution and $100 public defender fees.
Just point of clarification, is it just 1 year of community control, or is it then revert back to probation?
Just 1 year of community control.
Right, Your Honor, I think it would be reinstate with the next year on community control, followed by the remaining period on supervision. She's on supervision until.
That's not what counsel just said.
Okay.
What
We
is
could,
it?
just 1 year community control, the state's fine with. She can complete 1 year of community control
Okay,
with
so
the
our-
original terms and conditions.
Okay, so our new termination date will be 1 year from today.
Today,
Is that
yes.
correct? Fine, Judge.
Okay, very good, that's good, just wanted to clarify. Ma'am, would you raise your right hand? States in agreement, obviously. States in agreement, yes.
Yes, Your Honor.
Ma'am, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you understand, you're entering into this, agreeing to modify your probation to 1 year of community control.
Yes,
Have you
sir.
gone over what that means?
Yes, sir, I'm aware.
A lot more details. It's basically, I like the kind of the common use language is basically house arrest, okay? And that means it's not like, curfew and all, it's like house arrest. You can't go out unless you're working, blah, blah. You understand all that? You've gone over all those details? And you understand you're waiving the right to go to a trial and to contest all this? You believe this is in your best interest? Okay. And you've signed the plea and sentencing agreement, and you've gone over it in detail with your attorney. You satisfied with your attorney's representation of you?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement, an adjudication of guilt, reinstate, actually modify to 1 year of community control starting from today. So 1 additional year of community control starting from today. Okay.
Thank you.
And their cost and fees are as contained in the plea agreement. And I assume that no disagreement as far as the score sheet?
No, Your Honor.
Okay, thank you. Daryl Beasley.
Casey Etheridge for Mr. Beasley, and he would like to admit to the allegations in the affidavit and accept the state's offer. It would be adjudication of guilt, revoke and terminate 11 months and sentence to a new term, 11 months, 29 days of probation, same terms and conditions, attend weekly AA or NA meetings, $100 cost of prosecution, and $150 public defender fees.
Stated agreement.
Yes, Your Honor.
Mr. Beasley, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement. Is that your understanding, and are you in agreement with that? I see that you signed the plea and sentencing agreement. Did you go over this with your attorney? It's got some other details in it, et cetera. Okay. So the core of the agreement is an adjudication of guilt, revoke and terminate, probation, and then they're basically, a new term? It's a new term of 11 months, 29?
Yes.
Okay. And the same terms and conditions. Are the attendance at AA and NA, is that a new?
Yes, it is.
Yes.
That's new? Okay. Obviously, maybe for you, maybe the most important thing. I mean, we want you to be successful on this, and, that's one of the great fallacies that, particularly as men, we can go it alone. Sometimes we can't go it alone. We need help, support from other people. That's just human. So, but you need to engage in this. This is a formal thing. There's a lot of magic in those meetings because you got people working together. So, but you got to go to them. You got to be consistent. You willing to do that? You understand that by doing all this, you're waiving the right to go to a trial and contest all this. You believe it's in your best interest? Okay, very good. Based upon that, the court will accept your plea agreement as contained in here, revoke and terminate and begin a new term, 11 months, 29 days of probation with the same terms and conditions, with the addition of the weekly attendance, minimum weekly, can be more, minimum of weekly attendance at AANA meetings and the costs that are contained in here. Good luck, sir. Preston Beverly.
Casey Etheridge for Preston Beverly, and he would like to admit to the allegations in the affidavit and accept the state's offer. It would be, and I'm sorry, this is in 2020 CF 2105 and 2021 CF 73. And in 2020 CF 2105, it would be adjudication of guilt, reinstate to community control, same terms and conditions, $100 cost of prosecution, and $150 public defender fees. And then 2021 CF 73, it'd be adjudication of guilt, reinstate to community control, concurrent with 2020 CF 2105, same terms and conditions, $100 cost of prosecution, and $150 public defender fees.
When you say same terms and conditions, not same terms and conditions if it's now community control, is it?
Your Honor, he was previously on community
Okay.
control. He
Okay,
thought
I
he
didn't
wanted to
understand.
get off of community control, and so his probation officer violated him. He sees now that that was not the thing to do, so I'm giving him the chance to go back and try it again.
Thank you.
Mr. Beverly, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement.
Yes, sir.
Are you in agreement with that?
Yes, sir.
And did you go over it in detail with your attorney and make sure you understand? She explained to you all the legal ramifications of
Yes,
all
sir.
this? Obviously, the most important thing is the reinstatement to community control on both cases.
Yes, sir.
Okay, you've done community control, you know, a lot of rules and regulations, right?
Stay home.
House arrest,
Stay home.
but essentially, you know, we're kind of saving you from yourself at this point. Hopefully, you can work through this. We want you to be successful, but you got to understand that what the next step is of community control. You understand? I mean, I'm not saying, I'm
No more
just
chances.
telling, pardon?
No more chances after that.
Yeah, I mean, that's the reality of it. We want you to be successful, so most important thing, stay in good contact with your probation officer
Every Tuesday.
every Tuesday. Okay. You understand that by doing this, you're waiving the right to go to a trial and all that?
Yes, sir.
And you've had all your questions answered by your attorney?
Yes, sir.
Based upon all that, the court will accept your plea and sentencing agreement, and there'll be adjudication of guilt in both cases, reinstate to community control in the same terms and conditions, with additional costs and fees as contained in the plea and sentencing agreement. And defense's agreement on the score sheet.
Yes, Your Honor.
Thank you.
Let me see, how many points do I have?
I did ask you if you all states in agreement, didn't I? Brina Bonifay.
Casey Etheridge for Sabrina Bonifay, and we're here in 2021 CF 2846. And then we have a case that's set this afternoon that we would like to address, if the court's okay with that. She'd be entering a plea to both cases.
Okay. What's that case number this afternoon?
So it's 2022 CF 1600. It's on the arraignment docket.
docket?
Yes, Your Honor.
Okay.
And I guess she'd be entering a plea of not guilty, but then we're waiving arraignment, I guess, on that, and we're going to enter a plea today, Your Honor, on that case.
Very good.
Okay? And it would be on 2021 CF 2846. It'd be adjudication of guilt, revoke and terminate, and sentence to a term of 1 year of community control, a cost of supervision waived, same terms and conditions, an additional $100 cost of prosecution, and an additional $150 public defender fees. And then on case 22 CF 1600, it'd
What
be
are the charges on the 1600 case?
The 1600 case is possession of a controlled substance and introduction of contraband being the controlled substance.
Okay, I'm sorry, go ahead, Counsel.
And then, okay, and it would be 1 year community control concurrent with 2021 CF 2846, cost supervision waived, $515 in court costs, $100 cost of prosecution, $150 public defender fees, a substance abuse evaluation, any recommended treatment, and there'd be no possession or consumption of alcohol or controlled substances without a prescription.
State in agreement.
Yes, Your Honor. And then, I apologize, Your Honor, and count 2 would be adjudication of guilt, credit for time served, and then count 3 would be adjudication of guilt, 1 year community control concurrent.
Bryant, would you please raise your right hand? Do you swear or affirm the information I'm sorry, Ms.
Bonifay?
Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay, you heard your attorney state the terms of your plea agreement. Is that your understanding? Go ahead and sign it. Take your time.
Yes, sir. I had also asked if I was able to get Bridgeway classes too.
Yeah, which is what you'll be in as part of the substance abuse evaluations.
That's part of the way Bridgeway works is you have to do an evaluation, and they walk, then they can figure out exactly what services would be appropriate. So that's, when they say substance abuse evaluation, they're evaluating you so you can get those services. Okay. And I appreciate you asking about that. It may be the most important thing. You know, it's all well and good, we keep you at home under community control and all that, but, you know, we want you to be successful. And you understand what that means. And it's easy for us to get up here and pontificate and talk about it, but you got to do all the hard work. And it does, it's hard work. So you understand, though you've gone over this plea and sentencing agreement with your attorney, I see you signed it, and you had all your questions answered from your attorney. And basically, on both these counts here, they're, one, they're revoking and terminating probation, and 1 year of community control, and the other one is just 1 year of community control. They'll run at the same time. So they're concurrent, they're not stacked on top of one another. So it's 1 year total, community control. But understand, community control is serious. House arrest, like stay at home. You fool around, and I'm not saying this to scare you, but I'm saying this to be clear with you. Probation, community control, you know what the next step is. They're going to be recommending incarceration, prison. So it's not where we want you to go. We want you to be successful right here. You can get back out in the community and go about your life. But you got to stay in good contact. The most important thing is stay in contact with your probation officer. Work closely with them. If there's issues, let them know. Work with your counselors you're getting. You reach out, get that support, around you so that you can be successful on this. So you understand that by entering this agreement, you're waiving the right to go to a trial, et cetera. And you had all your legal questions answered, satisfied with your representation? Okay. Based upon all that, the court will accept the plea. Adjudication of guilt and 1 year of community control on both of them, served concurrently. On 1600, there will be a substance abuse evaluation, follow any recommended services, et cetera. And then counts 2 and 3, credit for time served, and 1 year concurrent. So all of them, there's actually 3 counts that are 1 year, all concurrent, all at the same time, okay? Touch base right there with the probation before you go.
Your Honor, from probation standpoint, thank you for talking to Ms. Bonifay, because we've tried to give her that speech before.
Okay.
The 3 times she's previously been on, she just skipped out on us every time, wouldn't even come to the office.
Yeah.
So thank you for trying to tell her that, because we try to tell her that same thing.
I mean, unfortunately, what I often tell people, and I'll say it to you straight, when you come back, you violate this again, and you're getting sentenced to prison, I ain't sentencing you. You just sentenced yourself. The words are just coming out of my mouth. So, and let me tell you, your best friends are sitting right next to you because they want you to be successful. Believe me, they're not in this business so they can send people to prison. They're in this business to try and keep people off the, to help them. Believe me, that's what they try and do. Autumn Bryant.
Casey Etheridge for Autumn Bryant. We're here in 2020 CF 2623. If I could just have 1 moment, Your Honor.
Bless you.
Your Honor, if we could pass this for a few minutes so that she can think about it. I'm gonna go talk to her, too.
Sure. Say, Elijah Daniel.
19 CF 804.
On that last case, what I had it down for is a bond hearing.
Yeah, I don't believe that I had filed a bond hearing in this. That's why I was confused. I don't know either.
There's a bond modification.
Oh, is there a bond modification? Oh, okay, well, we can
I
address
just
that
want to let
as
you know
well, Your
that,
Honor.
so when you're talking
Okay,
to her.
okay, thank you.
Okay.
All right, Casey Etheridge for Mr. Daniel. We're here in 2019 CF 804. And we'd be asking to set this for August 25th, Your Honor. He has some money that's outstanding. He's already completed one of the conditions. We're just, he'll be able to pay the money, and the state's going to let him do that. Extend this to 8/25.
So we're going to come back August 25th
Yes.
without subpoenas in the morning?
Yes, please, Your Honor.
Okay. 9 a.m., August 25th, without subpoenas. Hakeem Dixon.
But you need to get another copy so we can have it, okay, just in case. Casey Etheridge for Mr. Dixon. If I could just have one moment. Okay, Your Honor, Casey Etheridge for Mr. Dixon. We're here in 2018 CF 2695, 2019 CF 562, 2019 CF 1659, 2019 CF 1660, and 20 CF 835. These are all violations of probation. He does have a new law violation that is the sole reason for the violation, I believe, Your Honor.
And failure to report.
And failure to report. And so we would just ask, Your Honor, if we could, because I don't think we have all the discovery yet on the new case. And so we'd just be asking to, if we could put this, I guess, on the 824 docket with the new case.
I'm not aware
If
of
we could.
any outstanding discovery, but I have no objection to putting it all together on the 24th.
Okay. We'll continue this on to the pretrial docket on 8/24 at 9 a.m.
Thank you, Your Honor.
And that's without subpoenas.
That's our pretrial. That's actually our
Okay,
regular pretrial.
you're right, Judge,
docket.
9 a.m.
Yes, without
No
subpoenas.
need for subpoenas.
Cameron Doris.
Casey Etheridge for Cameron Doris. We're here for a bond hearing, Your Honor. In this case, this is case number 2022 CF 1396. We're here for a motion to reduce bond. Okay, and Your Honor, his bond is currently set at $110,000. There's some pending evaluations in this case due to mental health. And we're just asking if the court would lower the bond to an amount affordable so that he's able to be outside attending these appointments and everything like that, Your Honor, instead of being in jail. I know that he's having a rough time in jail, and I don't know if he's receiving all of his medications that he typically takes in jail, so.
Your Honor, Mr. Doris is charged with aggravated assault by threat with a firearm, a shotgun, criminal mischief, damaging a truck, the windshield and various parts of the truck, and possession of a controlled substance, being cocaine. I'm well aware that he has mental health issues. I think that in this particular situation, he's a danger, and I would request further input from a mental health evaluator.
Where are we at with that, as far as the evaluation?
The request has been made, defense has made the request.
It's pending. Yeah, I'm just waiting for a report, or I'm not sure.
So
Is she gonna see you?
there's already been an interview?
We discussed this last time.
As far as I know, I'm not sure if she's been to see him or not. It's Dr. McDonald. I'm just not sure if she's, and he's not sure. Like, I think he's very confused. So.
Got to give me some information for,
Okay.
we were here last time, help me out.
Previously, we were here on this, I believe, the same issue, and
When was it, how long ago?
a couple of weeks ago.
Couple weeks, yeah.
We were here. It was his first appearance, first time appearing, so I guess it would have been arraignment.
Yeah.
Your Honor, the issue came up, the state expressed their concerns and requested that a mental health evaluation be conducted before we would agree to any different position.
So, what I would offer is that I'll be glad to, if there's anything that needs to be done to move this, we need to get if the evaluation's been done, we're waiting for, we need to, first of all, you need to call, if it's been done, his office,
I don't know
her
that it's been
office,
done, yeah.
her office, right? Should know whether the evaluation, whether they're waiting for him, or you can just, simple call can make that, and if
Yeah.
there's anything I can do to try and do it, let's,
Okay.
we'll put it on again on August 25th, just trying to move it along.
Yeah, he's set for the 24th, I think
Okay.
24th already, Your Honor, so.
So remind me of this, though, on
Okay.
the 24th.
Okay. Yeah, I'm hopeful we'll have a report by then. Your Honor, I think the issue is that there are unfortunately several pending evaluations that she's got on her desk, and I don't know if that's.
If it's an ongoing, if it's an unreasonable, what you guys got to help me with.
Right.
Is it an unreasonable delay, or is it
It's
kind of
not.
more of a normal, or are we having issues with that? If there's issues, then we need to, try to address it. They're obviously trying to work, I'm not blaming anybody, but
Yeah.
court can't do anything if we don't know about it.
Your Honor, we were here back on 6/28 for the original portion of the
Yeah.
bond hearing. This is a continuation thereof.
Yeah, that's a long time. We should, that's a month and a half,
Okay.
a little over a month.
Hearing before?
Not a bond, I don't know, not the bond hearing, but.
Oh, okay.
But the issue of the evaluation and whatnot.
Yeah.
So it should have been ongoing by that, so
Okay.
you're saying that he's not receiving his medications?
From what I'm understanding, he's not receiving all of his medications that he gets.
It could very well be, Your Honor, the standard practice
Right.
at the jail is if there's any issue or idea or possibility of drugs, which he's charged with drugs, that they do a 120-day dry out period, and they will not give them any mental health medication. So that could very well be what's happening.
Okay, so let's come back on 8/24 and let's see,
Okay.
try and at least get some good information, so.
Yeah, sure. I'm hopeful we'll have a report by then, so, as well. So,
Thank you very much. Curtis Farrell.
PC Etheridge for Curtis Farrell, and we're here in 2021 CF 2509 and 2021 CF 1388. If I,
Your Honor, in this particular case, the state had made an offer of $11.29. Defense did get me down to 270 days, but that's the best that I'm going to do. Otherwise, we can just go to violation of probation hearing. The state will be asking for, prison.
I was trying to get to like 6 months because I didn't feel like it was.
state's offer, so what would you like to do? Do you want to accept the state's offer, plead to the court?
We don't, you don't have to make a decision right now.
Well, Your Honor, this has been,
We've
just want to be
continued
frank.
this several
Yes.
times.
I
Yes.
haven't spoken to her about this, but
I understand that, but here's the deal. A negotiation is between the state and the defense. I understand you don't want to accept it, but it's a two-way deal. So you got an option. Either you can accept the state, in other words, have an agreement, or you can go to trial, or you can do a plea to the court and throw it at the mercy of the court, but you need to do that with eyes wide open, I mean, no telling, you can't trust what the judge is going to do. Or you can go to a trial. You have a right to, and so you got various levels of protection of your rights. You got to make the call. So,
I don't know. I'd like to have some time to think about
okay,
it.
I'm absolutely not forcing you. Okay. We'll come back. When's our next hearing?
Next week, Your Honor, on 8/4. And Your Honor, this is the third continuance, and and just for the record, I want to put on, I've been out to the jail to see him multiple times. All he wants to talk about is the underlying facts of the case, which are
Go
irrelevant
to
at
a
this point.
VOP. Let's
So-
set a hearing.
You want to just go ahead and set the hearing?
Let's set the hearing. We'll skip over 8/4. August 25th.
They have to prove the allegations against you. The ones that we
Going to a
told you.
trial.
Mhm.
Failure to report is the allegation.
Yes.
If you want to police something, you can.
No, I didn't report. I know that.
Okay, no. We're coming back for a VOP hearing on August 25th at 2 PM.
Your Honor, that's what I was going to let Mr. Carroll know. The question's going to be asked of me or Ms. Lovely, did he report? Our answer is going to be no.
Well,
And then I think Ms. Rivers is going to sit back down. So.
He'd be asking
I
for
just
state
want him to
prison.
know that.
Yes, I know.
Because he's earned it.
Okay, very good. Can't force you to do anything. That's not our job. Okay, thank you very much.
270 now then? Can I
I'm
just go
sorry?
ahead and do that?
I'm sorry?
Sign the 270 and be good?
Is the 270 still on the table?
That's fine, Your Honor.
Okay.
But does that, the charges that I was originally charged with, will that still be on my record?
Yes.
See, that was the problem I was having because whenever I did the probation, I didn't realize everything that I was talking about last time with the probation officer. Or not the probation officer.
We're not here on that. I can't address it because we're not here on the underlying charge. We're here on a violation. I'm not trying to discount it. I don't know. So I
See, I was trying to go
understand
back
understand what your issue is, but this isn't the right hearing and this isn't the right procedure to do that. And I suspect your attorney has gone over this with you because she's quite experienced with all this. Anyway.
How do you go to prison on a 42-point system? I don't get how that is. And you're looking at 2 years on
Okay,
probation.
I need to ask you a few questions on this. Mr. Farrow, would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, and nothing but the truth, so help you God? Okay. There's been a lot of discussion. You've got an offer, the primary offer is revoke and terminate probation on both counts, both charges, and you would receive 270 days in the county jail with credit for time served on both charges, both 1388 and 2509. You would get credit for all time served. They'll run concurrent. They'll run at the same time, it's a total of 270. Is that your understanding of the plea agreement?
Yes, sir.
And are you in agreement with that?
Yes, I am now, yeah.
Okay. Did anybody threaten or coerce you to get you to enter into this plea?
They did to get me the last one that I'm in here right now on, yes.
Okay.
But
If you state that you've been coerced, then I'm not going to accept this plea. Here you go. We're not here to coerce you, sir. You got to do your voluntarily. I understand your issue, but I can't solve it today. So we'll come back on the August 25th for a hearing.
because I got, okay, all right.
Come back at 2 p.m. on August 25th. Thank you. Matthew Gray.
Etheridge from Matthew Gray, and we're here in 2019 CF 3446. Mr. Gray would like to admit to the allegations in the affidavit and accept the state's offer of adjudication of guilt, revoke and terminate probation, 11 months, 29 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fees, fines, and court costs reduced to judgment.
Very good. State in agreement?
Yes, Your Honor.
Mr. Gray, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. Go ahead and sign that first. All right, so you're signing a plea and sentencing agreement that contains what your attorney just stated. Is that your understanding of what the plea agreement is?
As long as I get my credit for time served, I'm good.
You will get credit for time served. The key thing, is that the core of it, your plea agreement is the 1129. You understand that? But just need to make sure you've gone over all the legal ins and outs of all this with your attorney. You feel like you understand, had all your legal questions answered?
All due respect, sir, this ain't my first time, so yes, sir.
Well, I understand that. But I got to keep asking you this because, you might have a complaint and I want to hear it.
Yes, sir, I understand.
And I want to make sure that, you've gotten all your legal answers, because, every case is a little different.
Yes, sir.
So, but I understand you know what you're doing. And I appreciate that.
Yes, sir.
So you understand that by entering this, you're waiving the right to go to a trial and all that. You've had all your legal questions answered, and you've signed this plea and sentencing agreement, gone over it with your attorney.
Yes, sir.
Nobody threatened or coerced you to get you to enter into this?
Nobody in the court system, sir.
Well, now, don't.
I'm just kidding.
It's easy to be flippant about it, but we're being serious about this. I
Yes,
want to
sir.
make sure that nobody coerced you, nobody promised you anything to get you to enter into this. Because if you do, then I can't accept it.
No, we're good.
Okay. Very good. Based upon that, court will accept your plea agreement on the violation of probation, adjudication of guilt, revoke and terminate probation, sentence you to 11 months, 29 days in the county jail. You will get credit for all time served. There's some fees and costs that go to collections that are contained in the agreement.
Yes, sir.
Thank you very much. Athena Griffith.
Casey Etheridge from Ms. Griffith. We're here in 2017 CF 2412, if I may have one moment. Casey Etheridge for Ms. Griffiths. She would like to enter a no contest plea to the state's recommendation. I'm sorry, she'd like to admit to the allegations in the affidavit. I apologize, Your Honor. And accept the state's offer to adjudication of guilt, revoke and terminate probation. It's 12.1 months in state prison with credit for time served since arrest for the violation of probation on June 12th of 2022. There's a $100 cost of prosecution, $150 public defender fees, and all fees, fines, and court costs reduced to judgment.
And would you raise your right hand?
Yes, sir.
You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God. Go ahead and sign that. Ms. Rivers, the stating agreement.
That's correct, Your Honor.
Is the defense in agreement on the score sheet?
Yes, Your Honor. Yes.
So, Ms. Griffith, you heard your attorney state the terms of your plea agreement. Is that what you're agreeing to here today?
I mean, yeah. I mean, I wish they would give me another chance so I can go like community control because my
I understand
husband,
that, but this is what they've offered, and
my husband's really sick and I don't, if I,
ma'am, my whole job here is to make sure, two things. To make sure that you understand what this plea agreement is and that it's freely and voluntarily entered into. I'm not a negotiator. I'm not a mediator. I'm just here making sure that your rights are protected. The negotiation between you, your defense attorney, and the state. I just need to make sure, are you in agreement with that? Nobody's coercing you here, and if you don't want to do this, you need more time, the court will give it to you. Believe me, I understand you're being sent to DOC. Nobody wants that. I understand that.
I just know my husband just had another heart attack and I don't know if I'll be able to see him again. That's why I was trying to ask if there's any way you can let me get my affairs in order or just.
I'm, at this point, I'm not here to enter into the negotiations. Are you wanting to enter this plea agreement or not?
I mean, I don't want to do 5 years.
Okay, ma'am. If you're not in agreement, I'm gonna ask you one more time. If you're not comfortable with it, I don't want to force you. I'm not here to force you. If you're not in agreement 100%, then I'm not going to accept your plea. We can move on down the road. You can come back a little later or reconsider it or whatever. Talk to your attorney more.
We'd like to go ahead and set it for contested.
What would you like to do, ma'am? Again, I'm not trying to coerce you. I need you to make sure you're clear about this.
I am, sir. But is there any possible way I can be able to get like a furlough for just maybe 5 hours just to be able to see my husband?
That is something that's separate. I wouldn't count on that, and I don't want you to accept it based on that. If your attorney wants to put a
I mean, he
something in,
just
I
had a
don't
heart
know, but
attack.
I don't know that I would expect that, quite frankly, because you're being sent to DOC. But I'm not here on that. Okay? So, what do you want to do?
Take the agreement, I guess.
So I see you've signed this plea and sentencing agreement. You've gone over it. You understand it with your attorney.
Will I get all my time?
And you get your time.
We'll get credit for time served. Is there a particular, you're getting credit for time served?
Since her VOP
Since
date.
the arrest on the VOP, which was June 12th of 2022. You get credit for all time served since that day.
Okay.
Okay. Is that your understanding of what the agreement is?
Yes, sir.
There's some costs and fees, they'll go to collection. You understand that by entering into this plea, you're waiving the right to go to a trial and to contest this?
Yes, sir.
You believe it's in your best interest to do that? Did anybody threaten or coerce you to get you to enter into this plea? And you're entering into this freely and voluntarily? Based upon that testimony, the court will accept your plea and sentencing agreement as contained in the agreement, adjudication of guilt based on the admission, Revoke and terminate probation, 12.1 months in Department of Corrections with credit for time served since the arrest on June 12, 2022. Fees and costs go to collections. Thank you, ma'am. Good luck.
Great.
Jacob Jensen.
Casey Etheridge for Jacob Jensen. We're here in 2022 CF 785. Mr. Jensen would like to, sorry, one moment, Your Honor. Okay. Would like to accept the state's offer in the 2022 CF 785. And it would be, there's 7 counts, Your Honor, just for the clerk, just listen to me. So it's adjudication of guilt on count 1, 24 months of probation, cost of supervision waived. Complete the Keaton program and any aftercare. Defendant will be held in custody until a representative from Keaton picks him up. No possession or consumption of alcohol or controlled substances without a prescription. $515 in court costs, $100 cost of prosecution, and $150 public defender fees. Count 2 will be adjudication of guilt, 24 months of probation concurrent with count 1. Count 3 will be adjudication of guilt, 24 months of probation concurrent with count 1. Count 4 will be adjudication of guilt, 24 months of probation concurrent with count 1. And then count 5, 6, and 7, be adjudication of guilt, credit for time served.
Is that the agreement, stated agreement?
Yes, Your Honor.
Mr. Jensen, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement.
Yes,
Is
sir.
that your understanding, and are you in agreement with that?
Yes, sir.
You understand that by entering in this plea agreement, you're waiving the right to go to a trial to contest all this violation of probation. Do you understand that?
Yes, sir.
This will be a final adjudication. In other words, it'll limit your ability to be able to appeal it, et cetera. Do you understand all that?
Yes, Your Honor.
You kind of asked all your legal questions that you have of your attorney regarding this plea agreement?
I have, Your Honor.
Okay, and I see you've signed the plea agreement. You've gone over the details of it with her?
Yes, sir.
And you're admitting the allegations contained in the plea and sentencing, in the violation of probation? Is that correct?
This is a new law case, Your Honor.
This is the new law, this is a
Yes.
new law case?
Yes.
Good. Yeah, I asked the question, we actually get clarified. So that's why I asked these questions, so.
Yes, sir.
Okay, so it'll be an adjudication of guilt, 24 months probation on 4 of the counts. They'll all be served concurrently. And the completion of the Keaton program will be, and aftercare will be a condition of it. You'll be able, they'll hold in custody until Keaton picks up. Is that your understanding?
Yes, sir.
Had all your legal questions answered by your attorney?
I have, Your Honor.
Okay. Very good. Based upon that, the court will accept your plea, and it'll be an adjudication of guilt on all counts. Counts 5, 6, and 7, credit for time served. Counts 1, 2, 3, and 4, it'll be 24 months probation, all served concurrently. Fees and costs will be paid as normal during the probation period.
Yes, sir.
Good luck. Thank you.
Thank you.
Your Honor, due to the fact he's going to Keaton, we request a supervision.
Yes. Waive the fees. Cost of supervision. Corey Jones.
Casey Etheridge for Corey Jones. We're here on 2020 CF 2921 and 2021 CF 231. And Your Honor, I believe he may be set on the afternoon docket for arraignment as well, and we're asking to go ahead and enter a plea of not guilty for today and set that for the next pretrial conference. We're asking to set all these cases on the pretrial conference date of 8/24. We have an investigator doing some investigation into the case, and we need some more time, and it's the basis for the violation.
Okay, and what's the case number in this afternoon?
Okay.
22 CF 1563.
And you're entering a not guilty on that, and we'll come back on all three cases, the 2921, 231, and then the 1563, all continue until the pretrial on 8/24.
Thank you, Your Honor.
Eddie Wilson.
Your Honor, this is Eddie Wilson, 21 CF 567, if we may approach.
You may.
Casey Etheridge for Eddie Wilson. We're here in 2021 CF 567. And Your Honor, we'd be asking for the court to modify Mr. Wilson's bond to an ROR for him to be released to Walton County at this time. For the
States in
holding.
agreement.
Yes, Your Honor.
The court will grant the request to have an ROR bond. It's just a signature bond. Well, it's not, yeah, an ROR bond. There is a hold in Walton County. It just allows you to be able to go over and deal with that count over in Walton County, so you don't end up having to go here and then go over there. So they'll be able to deal with it, okay? So there'll be a hold, there'll be an ROR, but there is a hold, so you'll basically be transported to Walton, okay? But it'll at least allow you to deal with that charge over in Walton County, okay? Okay.
And Your Honor, just for the record, when are we going to be setting Mr. Wilson's case, I guess is the...
I mean, certainly, we don't need to come back in August.
Right.
October at the earliest, just for kind of a where. Status.
Yeah.
So we'll come back. What is his bond over in Walton? So
He
we
hasn't
didn't
been, hasn't been arrested yet.
Oh, he hasn't been arrested. Okay. So we'll come back on October 26th for inmates.
Thank you, Your Honor.
Okay. Mr. Russell.
Yes, sir.
Maria Leckler. You know what, we, on Leon Knox, good question, we skipped right over it. Leon Knox, we've got Olivia Ramsey as the PD, but who, are you handling that, Ms. Etheridge?
I am.
Okay. Let's do Knox. I'm sorry, I skipped over that. My bad.
Casey Effridge for Mr. Knox. And, Your Honor, this is a return from Florida State Hospital. And I imagine that the court just needs to make a finding on the record and then set this for another date. And, Your Honor, we did want to address one issue as well.
Court's reviewed the comp eval, so what are you asking the state to do, with the court to do? I mean, it was competent, so you're asking for a ruling that he's competent to proceed?
Correct.
And based upon the evaluation, the court will rule that he's competent to proceed.
And then, Your Honor, prior to this, Mr. Knox had been out of custody where he was receiving treatment. The only reason he was taken into custody is because Florida State Hospital won't take you unless you're in custody. They won't come get you. And so it didn't specify that he needed to remain in custody on the order, but it also didn't specify that he could go back to his original term either. I believe this was Judge Flowers' order. So I'm just asking if the court would consider letting him back out on his original bond, since it was never revoked, really.
What was the original bond?
It may even have been pretrial release, I believe, the way I look.
Your Honor, just from looking at this, he had a violation of probation that was set for January 26, 2021. He then failed to appear. Then capias was served in March of 2021. Then he had his comp eval in May. Based on the fact that this is his second violation of probation, drugs do seem to be a reoccurring theme. State's somewhat reluctant on what the defense is suggesting.
Was he out at the time? What the defense is saying, he was out, essentially was placed, but put back in jail because that's the only way that the hospital would pick him up.
That's correct.
Is that correct? If that's correct, then he's now been delivered back from the hospital and he needs to be out on bond, if that is correct. There was some other reason why he's being held, that he violated something or,
Violation of probation.
well, I understand that, but
There's no notes, Your Honor, that, to that effect. I would just have to defer to defense.
You know, this was a lengthy review of the court docket. Obviously, I was not here at that point. And this is me reviewing the actual, court benchmark, reviewing everything that was said. And it just, it wasn't clearly addressed, but it said that he was being taken into custody because Florida State Hospital can't come get him otherwise. They won't go get him from his house. So.
Your Honor, I found another page of notes. I'm sorry. He didn't want to go, ran off, and he failed to appear. Yeah, he was on the outside, Your Honor. He was.
yeah, the issue was he wasn't. I also think there was some issue of cooperating with.
That's correct, Your Honor.
I can't say anything.
It doesn't matter if he was out before and he was placed in there in order to pick up, he should be released. Was he on pretrial services?
From what I'm understanding, yes.
And normally, I was going to say, normally Mr. Barnes comes with a plan, everything.
Mr. Barnes, don't be hiding back there. He tried to slide behind that gentleman there so I couldn't see you.
I was inquiring of Mr. Barnes, Your Honor, and the best I can recall was he was free world. The only way we could
He was what?
He was on bond.
He was, okay.
The only way we could get the Department of Children and Families to do the eval was he had to go from custody.
Right.
Couldn't do it from.
And that's what defense is
They
saying.
did it. They
So
took
you're
it.
confirming the defense, what the defense is saying, so he needs to be let out. So the question is, the court will release him on an ROR. The question is, was he on some type of pretrial services, and what were those, so we can return him to that? I want to return him to this. Mr. Barnes? Okay, so whatever the pretrial services were before, that's what we want to do. We want to return him to his status before he was placed in custody, only really for the purposes of pickup by the hospital.
Yes.
Your Honor, he was in custody as a result of a violation of probation. He was still on probation, so his form of supervision would be us.
Okay. Okay, very good. So not pretrial services?
Correct.
Okay, very good. I'm good with that.
Make sure you report to probation.
We would
Let you
need,
out. You gotta cooperate with probation, okay?
we would need, well, it's a violation of probation, so we need a new court date.
Right,
Yeah.
right,
I
correct,
understand
correct.
that. I just want to make sure that he's gonna work with us.
You know, could we set this for 8:25 so I have the opportunity
Sure.
to get well
8:25,
versed?
Without subpoenas in the morning?
That's fine, Your Honor.
Okay, very good.
Mr. Dunn, we will contact the probation officer, I think who's. We will contact the probation office down in the south end of the county. I think that's where he's being supervised out of, and let him know he's getting out of jail, and we will instruct him to report to that.
Okay, very good. Very good, thank you. Marie Leckler.
Charles Russell, Public Defender's Office Judge. This is Maria Leckler. She's here on 3 cases, 22 CF 103, 22 CF 244, and 22 CF 1374. If I could just have a moment. We've reached a plea agreement with the state judge. 103 and 244 are actually violations of probations. 1374 is a new law violation, but she's going to plead no contest to 1374, admit the violation of probations in the other 2 cases. The agreement we've reached is that the probation will be revoked and terminated. She will be adjudicated guilty on all counts, be sentenced to 150 days in the county jail, each count concurrent and coterminous. She'll get credit for any time served. She'll pay court costs in 22 CF 1374, $100 cost of prosecution in each case, $150 public defender fee in 22 CF 103, and then a $100 PD fee in the other 2 cases, and she will get 120 days after her release to pay, or it goes to collections. If I may approach.
The state in agreement?
Yes, Your Honor.
Ms. Leckler, is that how you pronounce your last name?
Yes, sir.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
I see you've signed the plea and sentencing agreement. Have you gone over it with your attorney in detail and understand all the terms and conditions of it?
Yes, Your Honor.
And you're in agreement with that? Yes. Obviously, the core of this is the 150 days in the county jail on each of the counts, all to be served concurrent. It means they're not stacked on top of one another, all at the same time.
Yes, sir.
You also got fees and costs, a bunch of them in different cases. You've got those laid out in the plea and sentencing agreement. You understand that you're responsible for those. 120 days after your release, they would go to collections if you're not able to pay it. Okay, so you understand all that.
Yes, sir.
You understand that by entering in this plea agreement, you're waiving the right to go to a trial, contest all these things, et cetera. You believe it's in your best interest to do so. Very good. Based upon your testimony, the court will accept your plea agreement, plea and sentencing agreement, the core of which is the adjudication of guilt on all counts, 150 days in the county jail on each count, all to be served concurrent along with fees and costs. Good luck, man.
And coterminous, Judge?
Yes,
Thank you, Judge.
Thank you, Your Honor.
thank you. Justin Mays.
Charles Russell, Public Defender's Office, Judge. This is Mr. Mays. Case number is 20 CF 881. Mr. Mays is before the court on a violation of probation that is based on a misdemeanor case that is still pending. We recently received a report finding Mr. Mays competent, so the misdemeanor attorney is now going to meet with Mr. Mays and discuss how to proceed on that case, and that will affect how we proceed on this case. So I'm asking that this be passed to 825 without subpoenas, and next time around, maybe we can resolve this case one way or the other or set it for hearing.
August 25th at 9 a.m., okay? Thank you. Zachary McKinney.
Charles Russell, Public Defender's Office, Judge. This is Zachary McKinney. Case number is 20 CF 555. At this time, we're going to ask for a continuance to 825 without subpoenas. We were trying to negotiate with the state, but because of recent events at the CAC, we're going to need a little bit more time.
Uh-oh. Now we got an additional reason for these delays.
Your Honor, we're recommending DOC on
No,
Mr.
I'm just
McKinney.
kidding. I'm just kidding. Believe me, we're all,
I didn't come up with that one.
no, you didn't.
No,
No,
Judge,
we're
seriously.
all quite,
Yeah.
I know everybody is, on all sides of this equation are sorry that occurred. So, the court will accept the
And is that-
continuance until August 25th at 9 a.m. I assume the state doesn't have any objection.
No objection, Your Honor. He is incarcerated, but that would be the last time. If then we'd ask for an evidentiary if we can't get it resolved.
Okay, very good.
Okay. So we'll see you.
Would the clerk make note of that last continuance on the VOP? Irene Morgan.
825. Charles Russell, Public Defender's Office. Judge, this is Kyrie Morgan, case number 18 CF 259, which is a violation of probation. Mr. Morgan, we've reached a plea agreement on the violation of probation. The violation of probation was based on a new law violation that was dropped, but the jail is not showing that yet, so I just wanted to put that on the record. His new law violation was case number 22 CF 1636, and the state filed a no prosecution on July 13th, 2022. And then this plea agreement here today on the violation of probation is an adjudication of guilt, sentencing him to time served, reinstate him to probation with the same terms and conditions, and then he would have to pay a $100 cost of prosecution and $150.
Sorry, maybe I didn't understand. I thought you said that the VOP is based on the new law charge that was dismissed.
It is, Judge.
I'm
I think
sorry.
I could prove the new law violation in a VOP hearing, lower standard.
Right.
It's basically constructive possession in a jointly occupied vehicle.
Okay, I just didn't quite, I didn't track what you were saying. Okay.
$100 cost of prosecution and $150 public defender fee, Judge, if I may approach.
State's in agreement.
Yes, Your Honor.
Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sir.
And the defense is in agreement on the score sheet?
Yes, Your Honor.
So, Mr. Morgan, you heard your attorney state the terms of the plea agreement, adjudication of guilt, credit for time served, reinstate probation, same terms and condition, $100 cost of prosecution, and the PD fee. You're in agreement with all that?
Yes, sir.
And you understand you're waiving the right to go to a trial to contest all these things?
Sir.
You believe it's in your best interest to do so?
Yes, sir.
Had all your legal questions answered by your attorney?
Yes, sir.
Okay. Based upon that, the court will accept your plea and adjudication of guilt, credit for time served, reinstate as probation, same terms and conditions. Fees and costs as contained in the agreement. Good luck.
And Madam Clerk, can you make sure on the minute sheet that it shows that
22 CF 1636 was dropped. Okay, thank you.
Uniqua Mosley.
Charles Russell, Public Defender's Office, Judge. This is Ms. Mosley. Case number is 21 CF 880. We've worked out a plea agreement on this case. Ms. Mosley is going to enter a plea to a lesser-included offense of a possession of controlled substance, which is a third-degree felony, level 3. In exchange for that plea, the recommended sentence is going to be an adjudication withheld, place her on probation for 12 months, waive the cost of supervision. She would pay standard court costs, $100 cost of prosecution, $150 public defender fee, that she would submit to a substance abuse evaluation and perform any recommended treatment. She would be subject to random urinalysis, not have any drugs or alcohol without a prescription. She's not to associate with any illegal drug users, and she is to perform 25 hours of community service work. May I approach?
That's the state's agreement, Judge.
And would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement. Is that what your understanding is of the plea agreement?
Yes, sir. Does that mean I won't have a felony?
You won't have a felony conviction.
Okay.
The adjudication will be withheld, so it's not an adjudication of guilt on the lesser included. It's a lesser included, but it is still a felony.
Will I still be able to vote, though?
Yes. You still will be able to vote. Okay. Any other questions that you have of your attorney? I just want to make sure you've had all your questions answered of your attorney.
Yes, he answered all my questions.
So you understand that there'll be an adjudication withheld, 12 months of probation, cost and fees, et cetera?
Yes, sir.
Can't associate with drug users, 25 hours, all those things? I see you signed the plea and sentencing agreement. You went over that with him.
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a trial.
Yes, sir.
Is the defense in agreement on the score sheet?
Yes, Your Honor.
Based upon your testimony, Ms. Mosley, the court will accept your plea agreement on the lesser included offense of possession of a controlled substance, withhold adjudication, 12 months probation, waive cost of supervision, and court cost as contained in the agreement. Good luck, ma'am. Talk to probation. Michael Poor.
Charles Russell, Public Defender's Office. Judge, this is Michael Poor. Case number is 20 CF 1775. Mr. Poor is here on a violation of probation. At this time, we're going to enter a denial. Ask that it be set for 8:25 without subpoenas.
Very good. We'll deny and come back on 8:25 at 9 a.m.
Thank you, Your Honor.
Thank you. Calvin Riley.
Okay. Christopher Quillen, Judge?
Where's Quillen?
I show him after Mr. Poor on my...
Quillen, my bad. Christopher Quillen.
Charles Russell, Public Defender's Office. Judge, this case is, case number is 20 CF 2677. We have a couple of matters before the court. Somebody sent us a request for a Nelson hearing, so we set it for a Nelson hearing. Mr. Quillen indicates to me that that's not his handwriting. He didn't file it, but I wanted to get that on the record first.
Okay, so there is no Nelson hearing, and the defendant does not request that. Okay.
Okay. And then the second thing is that we've worked out an agreement on his case. He is before the court on a violation of probation in this case. In exchange for admission of the violation of probation, the sentence is going to be an adjudication of guilt, that the remainder of his probation will be modified to community control with the original terms and conditions, plus the following. He will complete the Phoenix House program, Bars to Bed, perform 50 hours of community service work, have no alcohol or drugs without a prescription, be subject to random urinalysis, pay $100 cost of prosecution, and $150 public defender fee. May I approach, Judge?
Very good. State's in agreement, yes? Thank you. Mr. Quillen, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You understand, heard your attorney state the terms of the condition that are also contained in this plea and sentencing agreement. You've signed this, right?
Yes, sir.
Have you gone over this with your attorney, make sure you understand the terms and conditions?
Sure.
You are waiving some valuable rights, the right to go to a trial. This will be a final adjudication of this violation. Do you understand that?
Yes, sir.
And you believe that this is in your best interest? You understand the community control, higher supervision, basically house arrest. Do you understand that you're willing to do that?
Yes, sir.
Okay. Very good. And the Phoenix House Program, bars to bed, you understand that? You've had all that explained to you. Very good. Based upon that testimony, the court will accept your plea agreement with the terms and conditions as contained in there, with probation modified to community control and complete Phoenix House Program and the other terms and conditions contained in your plea agreement. Good luck.
And Your Honor, I talked to Mr. Russell. Mr. Russell said he already contacted Phoenix House. He has been accepted, and we will contact Phoenix House for him, tell them how he's
They're
ready
ready.
to go, and they'll come get him from the county jail.
Okay, very good. Good luck. Alvin Riley.
I'm sorry, Judge, can I bring up one more issue with Mr.
Sure.
Court? The Phoenix House program is usually about 18 months.
Right?
He doesn't have that long left. You want us just to address that at that time, if he's still in the program? Or do you want to try to address it now?
How long does he have left?
That's till
We'll address it if it comes up, I
Okay,
guess.
we're good, John. Thank you.
Thanks, good clarification. Thank you. Alvin Riley.
Charles Russell, Public Defender's Office. Judge, this is Mr. Riley. Case number is 22 CF 295. If I could have a moment. Judge, I think we've worked out an agreement on Mr. Riley's case, but I'm going to need some time to write it up and go back there and meet with him. So if we could just pass his case. And since we're close to the noon hour, I don't know if they keep him here, if they take him back for lunch and bring him back after lunch. And either one's fine with me. We can take care of it this morning.
Whatever you
this
all
afternoon.
do. I mean, I'm just,
Either one is fine with me,
or we
Judge.
just bring him back after the noon hour.
Yes, sir.
Okaloosa Rodriguez.
Ms. Simmons. Charles Russell, Public Defender's Office. This is Okaloosa Rodriguez. Case number is 22 CF 92 and 22 CF 743. Judge, this was set for a status conference because we were trying to get a report from Dr. McDonald. We still don't have that report. So I've let Dr. McDonald know that, that she's available to be talked to at the jail. And so at this time, we're just going to ask to put it on the pretrial conference,
Didn't
824.
we have a hearing, have this same conversation?
Your Honor, I believe Ms. Rodriguez was reluctant to cooperate initially, and the court spoke to her that it might be in her best interest.
That was
I think that
correct.
was the nature of the last hearing.
But then we haven't had any progress since then?
That would be Mr. Russell's knowledge, Your Honor.
That's
I don't know.
only since,
I'm not blaming anybody here. I mean, I'm just kind of, if we've got a kind of a,
I know we were here on June 29th. That might have been when we had that conversation. So do you know if Dr. McDonald has had an opportunity to go see her?
the last time I checked, she was on her list. That's all I can tell the court. To go see at the jail.
I currently have a case plan available that we've been trying to inquire.
Has Dr. McDonald come to see you? Again?
No, I'm not really, we're not really sure of that.
referring to the dependency case plan problem.
Yeah, we're trying to obtain you as a guardian ad without penitence, if that's possible, to be able to have these documents signed today.
I think that's a slightly different, it's a different case, so I don't think that's something that I can deal with, even though I used to, but I'm not now.
And
I mean, we have the documents here provided to you for you.
And I
Not
can-
something that I can handle today.
And I'll check with the doctor between now and 8:24, Judge.
Okay, so we'll come back on 8:25 at 9 a.m.
25 or 4?
Well, that's pre-trial, but if,
Right, either one is fine with me, Judge. 8:25 would be less crowded.
let's do 8:25.
See you back on 8:25.
Curtis Simmons.
Charles Russell, Public Defender's Office, Judge. This is Curtis Simmons. Case number is 21 CF 3258. If I could have a moment. Judge, we've reached an agreement with the state. This is a violation of probation. In exchange for admission on the violation of probation, the sentence is going to be an adjudication of guilt, 15 months in the Department of Corrections with credit for any time served. He would pay a $100 cost of prosecution, $150 public defender fee. Any money owed would go to collections, and probation will be revoked and terminated.
That's correct, Your Honor.
Mr. Simmons, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, you heard your attorney state the terms of the plea agreement. Is
Yes,
that
sir.
your understanding of what the plea agreement is?
Yes, sir.
Are you in agreement with that?
Yes, sir.
I see that the same things are contained in this actual written plea agreement that you've signed. Have you gone over this with your attorney? Make sure you have all your questions answered regarding this?
Yes, sir.
And you understand that by doing this, you're waiving the right to go to a trial and contest this. You're waiving some valuable rights. Have you gone over that with your attorney to understand that?
Sir.
Did anybody threaten or coerce you to get you to enter into this plea?
No, sir.
Do you believe it's in your best interest to enter into this? Are you satisfied with the representation of your attorney?
Sir.
Okay, very good. Court will accept your plea. There'll be an adjudication of guilt, 15 months, Department of Corrections. You will get credit for all time served. Probation will be revoked and terminated, and all fees and costs, including these fees and costs, will go to collections. Defense in agreement on the score sheet?
Yes, Your Honor.
Thank you. Good luck, sir. Cynthia Smith.
Charles Russell, Public Defender's Office. Ms. Smith is present and approaching. Case number is 21 CF 1381. Ms. Smith is before the court on a violation of probation. We have reached an agreement with the state in exchange for an admission of the violation of probation. It's going to be an adjudication of guilt. Probation will be restored and modified. She'll be subject to completing the original terms and conditions. The next 12 months will be on community control, and any remainder after that will be standard probation. She'll have a substance abuse evaluation within 30 days of today and begin any recommended treatment within 60 days of today. She can have no alcohol or drugs without a prescription, pay a $100 cost of prosecution and a $150 public defender fee, and I'm going to add waive cost of supervision.
State's agreement.
Yes, Your Honor.
Ms. Smith, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
You heard your attorney state the terms of the plea and sentencing agreement.
Yes, Your Honor.
Is that what your understanding of the agreement
Yes, Your
is?
Honor.
And are you in agreement?
Yes, Your Honor.
So you've signed the plea and sentencing agreement. It contains the same information and actually a little more detail. So have you gone over this with your attorney? Make sure you kind of understand kind of the legal ins and outs of what this means?
Yes, Your Honor.
You understand that by entering this plea agreement, you're waiving the right to go to a trial and to contest all this?
Yes, Your Honor.
Valuable legal right. And the core of this plea and sentencing agreement was you'd have the original probation is longer than the 12 months. So basically, the next 12 months will be community control. The remainder of your probation will be regular probation. Is that your understanding?
Yes, sir. Yes, Your Honor.
And you've had explained to me about community control, right?
Yes, sir.
House arrest,
Yes, Your Honor.
can't go out. Important, because the next step usually from community control, somebody's going to be recommending DOC.
Yes, Your Honor.
Don't want that.
No.
So work with probation and stay on top of this. And it's important that the substance abuse evaluation, that's probably the most important thing here. So do that as soon as possible so you can get going on that. Establish some good lines of communication with the probation office so that there are bumps along the way, they'll work with you, okay? Based upon that testimony of the defendant, the court will accept the plea agreement as contained in the plea and sentencing agreement. Good luck, ma'am. Christopher Stearns.
Charles Russell Public Defender's Office, Judge, this is Mr. Stearns, case number is 21 CF 1357. Mr. Stearns is before the court on a violation of probation. It's a misdemeanor count. The felony count was dismissed at the time of the plea. He's going to admit the violation. Probation will be revoked and terminated, be adjudicated guilty of the misdemeanor offense, be sentenced to 90 days in the county jail with credit for any time served, ordered to pay $100 cost of prosecution, $150 public defender fee, and he would have 120 days after release to pay, or the money would go to collections.
That's the agreement, Your Honor.
Very good. Mr. Stearns, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement. You can put your hand down.
Yes,
Is
sir.
that your understanding of what the plea agreement is? And I see you've signed the bottom of this written plea agreement.
Yes, I
Same
have.
things contained in there. You've gone over it with your attorney, make sure you got all your legal questions answered.
Yes, sir.
You understand that you're revoking and terminating probation. So no more probation, but you will get 90 days in the county jail. You'll get credit for all time served,
Yes, sir.
okay? Is that your understanding of what everything is?
Yes, it is.
Fees and costs, you have 120 days after you get released, and then it goes to collections.
Yes, sir.
You understand this is the final resolution of your case?
Mm-hmm. Yes,
Good
sir.
with that?
Yes, I
I
am.
believe it's in your best interest.
It is in my best interest.
Very good. Based upon that testimony, the court will accept your plea agreement, revoke and terminate probation, adjudicate the defendant guilty, sentence to 90 days in the county jail, credit for all time served, as well as fees and costs. Good luck. Tidwell.
Charles Russell Public Defender's Office, Judge, this is William Tidwell. Case number is 20 CF 3232. We've worked out a plea agreement with the state in exchange for a plea of no contest to the charges. The recommended sentences on counts 1 through 3, which are all misdemeanors and adjudication of guilt, but on count 4, which is the felony, adjudication will be withheld. He'll be sentenced to time served on all counts, be ordered to pay court costs, $100 cost of prosecution, $150 public defender fee, and he would be given 180 days to set up a payment plan, or the money would go to collections.
You may.
That's the agreement, Your Honor.
So, Mr. Tidwell, did you hear and understand what your attorney stated as well as the terms of your plea agreement?
Yes, sir.
Okay. The core of this is that you'll get credit for all time served. Basically, it's fees and costs. You're not going to be on probation, no jail time. You'll get credit for time served. Anything you've done is already registered, so you're not going to have any jail time, no probation. You understand all that?
Yes, sir.
But there are fees and costs, and they'll go to collections if you can't set something up in 180 days, about 6 months. Is that your understanding of everything?
Yes, sir.
You understand that by entering this, you'll be finally adjudicating, this will be a final resolution of your case. You understand that?
Yes, sir.
Okay, do you have any questions regarding what's gone on here?
No, sir.
And the defense is in agreement on the score sheet?
Yes, Your Honor.
Okay, very good. So the court will accept it and sentence you to you'll get credit for time served on all counts. Okay?
Thank you, Your Honor.
Any questions?
No, sir.
Okay, good luck.
Thank you.
Kyler Weir.
Okay. Well,
I'll let them tell me whether.
Weir, yeah, Weir.
Charles Russell, Public Defender's Office, Judge. This is Kyler Weir. Case number is 22 CF 1106. We've worked on an agreement with the state in exchange for a plea of no contest to the charges. Adjudication will be withheld. He'll be sentenced to time served, be assessed court costs, $100 cost prosecution, $150 public defender fee. He'll have 120 days after his release to pay, or the money goes to collections, and the state is taking no action on the failure to appear.
That's correct, Your Honor.
Very good, thank you. Mr. Weir, is that how you pronounce your last name, Weir?
Yes, sir.
Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. It's basically credit for time served, right?
Yes, sir.
You're going to have to pay some court costs and fees. You got to pay it within 120 days, or it'll go to collections. Is that your understanding?
Yes, sir.
You understand that by entering this plea agreement, your final resolution of your cases, you can put your hand down. Final resolution of your cases, you're done with this. Do you understand that?
Yes, sir.
Okay. Have you had all of your legal questions answered by your attorney about this plea agreement?
Yes, sir.
I see you signed the written plea agreement. You went over it with him?
Yes, sir.
Okay, very good. Any questions concerning the plea agreement? Okay. And the defense is okay with the score sheet?
Yes, Your Honor.
So, Mr. Weir, based upon your testimony, the court will accept the plea and sentencing agreement. Adjudication will be withheld. You will get credit for time served, no further sentence. You'll be able to be released immediately. You'll have court costs and fees that'll have to be paid in 120 days, and they'll go to collections.
Thank you, sir.
Okay, good luck.
Thank you.
Daniel Whitted. We'll take a break until 30.
Charles Russell, Public Defender's Office, Judge. This is Daniel Whitted. Case number is 21 CF 3051. If I could have a moment. That's what they talk about, prior record. 10 years after release, all that kind of other junk. Judge, on Mr. Whitted's case, at this time, we would like to ask for a continuance. Mr. Whitted has asked me to look into a couple things to present to the state to see if we can come up with some kind of negotiated agreement on the case.
So you want to come back on 8/25 or just do a general pretrial?
8/25 at night. This is a VOP, Judge.
Very good. 8/25 without subpoenas at 9 a.m.
Thank you, Judge. Be in touch.
Mr. Harper, anything you need to do before we go? I mean, you've been here, and I know you didn't have any cases. I just didn't know if I would have
noticed
called
that-
you earlier if I'd have known.
That's fine, Judge.
I know you've got one in the afternoon.
Yes, sir. I noted that the one in the afternoon had been transported this morning, Samuel Mosley. He arrived 2 days ago from DOC, and I met with him yesterday. Based on that meeting, and I conveyed this to the state yesterday as well, I think that it would be prudent of me to continue it. He wants to subpoena some witnesses for an evidentiary hearing, and I obviously wasn't able to do that within that timeframe. So I would ask to continue this for one cycle, and I know that the state has a witness, and I didn't want to leave them in limbo. And I think the state's okay with a continuance of one month to give time to facilitate that, Judge, if the court would permit.
I know it was lengthy. I did spend some time yesterday prepping it.
And Your Honor, the court also has the benefit, I hope, of our response initially, too.
I do.
Okay.
I do, and I reviewed it.
Your Honor,
That's fine. I mean, if the state's in agreement, and I understand there are quite a few allegations.
Yes, sir.
So,
we just wanted to let Mr. McKinney know if, in fact, the court would grant that, then he wouldn't need to come up from Shalimar, so.
And one of the parts that's difficult, Judge, is that one of the witnesses he wants me to subpoena may be difficult for me to find, so I just would ask for that month to hopefully.
so when do you want to try and, you want to do it September 8th, maybe? Is that too soon? Too long?
There were some dates, Your Honor, that Mr. McKinney was going to be out of town, but I believe that was not one of them, so that would be all right for me.
September 8th is fine with me, Judge.
No, I'm sorry, Your Honor, he is at a conference between September 5th and September 9th. I had already asked him if he was going to be available.
Where are we at? What are we at August 25th in the afternoon? How long, this is going to be, I mean, if we actually have it, it's going to be a good hour or no?
I anticipate at least 2 to 3 witnesses from my end, as well as I'm anticipating Mr. McKinney on the state side. I'm not certain if they're calling Ms. Sutton as well, but
Hard, sir.
We are. Mosley's here.
he was brought this morning, Judge, that's why. Sure, I spoke to him about this and procedurally where we might be at.
Assumed he wasn't, hadn't been brought over.
Yes, sir.
Go ahead and announce the case number.
Judge Rudy Harper on behalf of Mr. Mosley, before the court on 16 CF 2013. Judge, as I explained before, and I'm going to explain for Mr. Mosley's benefit, some of the witnesses that I think are pertinent to address the issues at hand in Mr. Mosley's motion will need to be subpoenaed for hearing. I'm asking for some time to facilitate that. And so I'd ask for one continuance to whatever next is next evidentiary hearing date.
Your Honor, we understand. We've got no objection to that.
Okay, so after September 8th, we don't have something until September 29th.
That would be fine with us. Like I say, our witness is Mr. McKinney, and he appears to be available for that day.
And I'll get everybody subpoenaed, that should be fine.
And that will be a couple hours, if you'll make note of that, Madam Clerk. Okay, and you will be transported over, so.
And just, I
Go ahead.
apologize for interrupting, Judge.
That's all right.
Just for the record, to ensure that he's not transported back to CI, I would ask that the jail could be made aware that we're continuing this and if he could stay here. I don't know.
You're asking him to hold here for the whole 2 months? I don't know.
Are you okay with that, or do you want me to? I can, he can be sent back, Judge. He's been sentenced to life, so it's not an issue with respect to gain time. It's just,
I'm trying to be sensitive to all the parties that are involved with it, the transport, the jail, the,
yes, sir.
I mean, I'm open to some suggestions or.
I'm fine with transporting him back, Judge. I believe that Mr. Mosley is okay with that. I'll just
I'll just send an order in motion
Okay.
to transport him back here after that.
Very good.
If there's anything you're missing from the record, just let me know.
Okay, very good. Very good. Thank you very much.
29th.
So we
Thank you,
obviously
Judge.
won't need to come back this afternoon on this.
Yes, sir. Thank you.
Is that your only case?
No, sir, I do have sentencing this afternoon with you.
Judge, I think there's a couple more yet.
You got more?
James Mattingly that you put me on earlier, and I went back and talked to him.
Okay, hold on a second. Let me,
Page
Okay,
6,
yep,
number
yep.
17. Charles Russell, Public Defender's Office. Judge, this is James Mattingly. Case number is 19 CF 1468. I talked to Mr. Mattingly in the back about the state's plea offer. At this time, he's going to decline it. I understand it's a VOP, so at this time, we're going to enter denial. Ask for 8:25 at 9.
8:25 at 9 a.m.
Is there any way that I just ask her for all credit for time served? Maybe she'll.
That's it. Yarwood. Charles Russell, Public Defender's Office. Judge, this is Bruce Yarwood. Case number is 21 CF 320. Mr. Yarwood is on your afternoon 2 o'clock docket probably. But he
Right.
was transported early this morning because we've worked out an agreement with the state. If I could have a moment.
Okay.
Just sign right here. This is a violation of probation, Judge. Mr. Yarwood is going to admit the violation of probation, but he's going to plead straight up to the court and ask for a sentencing hearing to be set down the line. That'll give us some time to get some witnesses and stuff together for the court's consideration. And I have a score sheet too.
And Your Honor, just for the court's knowledge, Mr. Yarwood does have a 5-year suspended sentence on this case, and his minimum guidelines are 42.5 months DOC.
Okay. So, Mr. Yarwood, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
So help me God, it is.
Okay. So, I'm looking at your plea agreement. This is a little bit different plea agreement. You're agreeing to a plea. I assume this is a no contest plea or an admission of the...
An admission of the VOP, Judge.
Okay, an admission of the VOP, but we're not doing it based upon a specific agreement. You're doing it basically, you're pleading up, it's called plea to the court. In other words, you're going to allow the court to make a sentencing determination based upon input and arguments from your counsel and the state, et cetera. You understand that it's a little bit different. Has there been any promises made for you on this? You understand this, there's limitations of what the court can sentence. Have you gone over the different options that might be available to with your defense attorney? I just want to make sure you understand what you're doing here. I don't want you to come and, I hear something, one way or another, and I sentence you and go, whoa, I didn't agree to that. I didn't think they told me this or that. I just want to make sure there haven't been any promises made.
No promises. On what we had discussed before was that there would be some mental health evaluations done, which have been done, and then look at possible options that way and gather letters.
And those mental health evaluations will be provided to the court, and there can be arguments made regarding them, et cetera. And you understand that by entering this will, except for the sentencing, this will resolve your case.
Sir, I do.
Make it harder to appeal it in the future, et cetera, no matter what I do. Do you understand that?
I do, yes, sir.
So you feel like you've gotten all your questions answered from your attorney about this, and it's a little bit unique?
Yes, sir, I do.
And the defense is in agreement with regard to the score sheet. That's obviously very important in this particular case.
Yes, Your Honor.
And the state's in agreement.
Yes, Your Honor, and as I indicated, there's a 5-year suspended as well.
Very good. Okay, court will accept your plea, and it's a straight-up plea to the court, and we'll set how long of a sentencing?
I'm going to have a few witnesses, Judge. I haven't decided. We're going to get Dr. McDonald involved. I haven't decided whether just to use her report or have her testify yet. At most, I would think 45 minutes to an hour, but no longer than that.
Hour.
Just argument, Your Honor.
Okay. How long out do we need?
Is 8:25 full?
Where are we at? 25. Any real long ones? If it's only 3.
Aikens won't take too long.
I think we can do it on the 25th.
So 8:25 at 2, Judge?
Yes.
Thanks, sir.
Okay.
Thank you, Mr. Russell.
Is that the last of yours, Mr. Russell? You got
Your Honor,
another?
we still have from the morning docket, Autumn Bryant.
Okay.
Yes, sir, please.
Yeah, she's done.
I'll talk to him after lunch, Steve.
You're not going to let me have any lunch, are you?
Nope. Casey Etheridge for Autumn Bryant. Ms. Bryant would like to admit the allegations in the affidavit, and she would like to enter a plea straight up to the court and set off for sentencing.
Okay, wait a minute.
May I approach her?
You may, thank you.
Yeah. This is it.
Thank you. So originally, I had this scheduled for a bond hearing.
Yes.
So we're changing this to a straight-up plea.
Yes, Your Honor.
Okay. So, Ms. Bryant, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. So you've kind of changed where the direction y'all are going. You've entered into a plea agreement. It's called a plea to the court. So you're basically agreeing to and admit, is this under the underlying charge?
Yes.
Okay. So you're agreeing to a no contest on this, but you're not agreeing to a specific sentence. You're letting the court make that call. You'll be able to argue it. State will argue. You understand, you know what the maximum sentence is in this case? Not saying that's what we're going to do. I just want you to know what the maximum is. Do you know what the maximum is?
Yes, sir.
What is it?
5 years.
Okay. You've gone over the different options that you have and what might occur, and you feel that this is in your best interest to do this? Okay. You understand that by entering into this plea agreement, this will be a final resolution of this portion of your case. Okay? You can't come back and say, well, gosh, that's a harsher sentence than I thought. I don't want to do that. Okay? This will be this part, and then the sentencing, you'll be able to argue, and the court will have to make a decision on that. You understand that? You've gone over all kind of how that works legally with your attorney? Do you have any other questions of your attorney? Very good. Based upon that, the court will accept your plea. No contest on the single charge, battery on a law enforcement officer, and it'll be a plea to the court. We'll come back. How long do you all need?
Well, Your Honor, I'll just make sure the court is not asking for a pre-sentence investigation. That's what
I don't think a pre-sentence investigation will be necessary unless the state's on
No,
this
Your Honor.
case.
Okay. Then we're okay with I mean, 8:25, however, or wherever.
Let's do it on 8:25, hopefully we can get it. It'll mainly be arguments, there are going to be some witnesses maybe.
You may have a few family members here, but I don't think it's anything.
Very good. Okay, thank you very much.
Okay. And that will be at 2? Okay.
All right. Anything else, anything else, sir? That it? All right. Yes, yeah, Riley? Okay. Okay, thank you all very much. We will reconvene at 1:30.
person is the code
Uh-huh.
Gotcha,
All rise, court is back in session.
Please be seated.
She had to go. She went to prison.
Okay, we'll begin our afternoon miscellaneous criminal docket. This portion of the docket is the arraignment. And just one comment for those of you all who are here, particularly what I'm directing this to are those individuals who have received notice of the arraignment but have not had an attorney appointed, or you've not hired an attorney. You always have a right at any point to hire your own attorney, so don't worry about that. But if you're here today and you don't have an attorney, the first thing I'm going to do, the purpose of today's hearing is to enter a plea. Guilty, not guilty, no contest. So, but if you're here without an attorney, you need to talk with an attorney before you. I mean, there may be, if it's not a serious charge, there might be a plea agreement that you might consider entering into without the benefit of legal counsel. But as a general rule, you don't want to do anything without understanding what the legal ramifications are, which means having a chance to sit down and talk to an attorney about it. So if you're here without an attorney, come forward, stand at the podium as quickly as you can. We'll get through this, but I'm going to ask you if you want an attorney. And I'm going to appoint you an attorney if you say yes, which you should do unless you're going to hire your own. And then we'll enter a not guilty plea so that you preserve your legal rights. We'll then come back, you'll have a chance to meet with your attorney, then you can figure out where you're going with the case. So I just wanted you to know that if your name is called and you don't have an attorney, come on down. We'll get through this portion fairly quickly. So we'll begin with William Baggett. If the state would announce this.
Yes, Your Honor. William Baggett's before the court on 22 CF 1513. He is charged with 3 counts of possession of controlled substance, 1 count of possession of drug paraphernalia, and 1 count of driving while license suspended.
Okay, so
I need an attorney, sir.
court will appoint the public defender. Court's going to issue going to enter a not guilty plea. We're going to come back, is August 22nd on a pretrial too soon, or can
No.
we just go ahead and do it? Okay.
No, Your Honor.
So we'll come back August 22nd at 9 a.m. And if you can try and meet with your attorney before then, that's what you need to do. And then Brina Bonifay, we dealt with that this morning, didn't we?
Correct, Your Honor.
Malik Bradshaw. Would the state announce, please?
Mr. Bradshaw is before the court on 22 CF 1580. He is charged with 1 count of fleeing and attempting to elude and driving while license revoked.
Okay. Again, Mr. Bradshaw, you do have a right to an attorney. You wish to have an attorney appointed?
Yes, sir.
Court will appoint the public defender. Court will enter a not guilty plea. We'll come back on August 22nd at 9 a.m.
Thank you.
Dawn Byers. Byers.
Ms. Byers is present. Coming. She's before the court on 22 CF 1606. She is charged with driving while license suspended, habitual offender.
Ma'am, as I stated, you have a right to an attorney. You wish to have an attorney appointed? Court will appoint the public defender. Court will enter a not guilty plea. We'll set the next hearing date on August 22nd, 9 a.m. Meet with your attorney in the interim, ma'am. Okay.
My what?
Gregory Cash.
22 CF 1548.
Etheridge.
Yeah, sure. Casey Etheridge for Gregory Cash, and Your Honor, we would like to enter a plea of not guilty for today and set this for the pretrial conference docket.
Very good. Pretrial conference, August 22nd, 9 a.m.
Thank you, Your Honor.
Meet with your attorney. It's wet out there, isn't it? Great, the skies are opening up. Timothy Kerr.
Casey Etheridge for Timothy Kerr. We're here in 2022 CF 1658. We will be entering a plea of not guilty for today and setting this for the pretrial conference docket.
Very good. Enter not guilty, come back 22nd of August, 9 a.m.
Okay.
You beat the storm?
Just barely. I did not. I came in barefooted though, Judge, and I put my shoes on before I came in here.
You did have an umbrella though, right? I mean, it's unbelievable out there. Brittany Clenny.
Clenny.
Clenny?
Yeah, Clenny, I believe, Your Honor. Casey Etheridge for Ms. Clenny, and we're here in 2022 CF 156. So she would like to enter a plea of no contest today, accept the state's offer. Count one would be adjudication of guilt, credit for time served, $515 in court costs, $100 cost of prosecution, $150 public defender fees, $101.83 for cost of transportation. And she'll have 180 days to pay, or it'll be reduced to judgment. And count two, adjudication of guilt, credit for time served.
Very good. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sir.
Just might want to make sure your plea is being entered free and voluntarily. You heard the terms of the plea agreement. It's basically credit for time served on these with a bunch of course, they always get you with a passel full of court costs and fees.
Yes, sir.
But you had that outlined. I see you've signed the plea and sentencing agreement. Have you gone over it with your attorney to understand what it is you're doing? Because there is an adjudication of guilt, so it's on your record. You've gone over kind of what this means legally.
Yes, sir.
You understand this is a final resolution of your case. You're waiving the right to go to a trial. Very good. Based upon your testimony, the court will accept your plea agreement and sentence you credit for time served, and then the fees and costs be payable over the next 180 days. If not, it'll go to collections. Okay? Very good. Joshua Coley.
Casey Etheridge for Joshua Coley. We're here in 2022 CF 1481 and 2022 CF 1482. And Your Honor, we'd be entering a plea of not guilty for today and asking to set this on the pretrial conference docket.
Very good. Enter not guilty. Come back on 8/22 at 9 a.m. Be in contact with your attorney before the next hearing, okay? Nathan Craig. State announce.
Your Honor, Mr. McCraig is before the court on 22 CF 1553. He is charged with driving without a valid driver's license and counterfeiting license plates or validation stickers.
And Mr. Craig, you do have right to an attorney. You wish to have an attorney appointed?
Yes, anyone.
Court will appoint a public defender. Court's going to enter a not guilty plea on your behalf. We'll come back on 8/22 at 9 a.m. Try and meet with your attorney before then, okay?
Yes, ma'am.
Okay.
Yes, sir.
Brianna Cumby.
Okay.
State announce, please.
Your Honor, Ms. Cumby is before the court on 22 CF 1722, 22 CF 1601.
Okay. Ms. Cumby, you heard me. You do have a right to have an attorney appointed in this matter. You wish to have an attorney appointed?
Yes, sir.
Okay. Court will appoint the public defender, And the court's going to enter a not guilty plea on your behalf so you can meet with your attorney, come back on the 22nd of August, 8/22, 9 a.m., okay?
Okay, thank you,
So
sir.
meet with your attorney.
Okay, thank you.
Okay. Terrell Flournoy. Inmate. Yeah.
You too.
They're bringing up Flournoy.
Okay.
Yeah, they're bringing.
Sorry, I missed that. I was like,
That's all right.
me?
Yeah, we announced.
Casey Etheridge from Mr. Flournoy, and we're here in 2022 CF 1603. And we'll be entering a plea of not guilty for today and setting this for the pretrial conference date.
Very good. The court will enter a not guilty plea, and we'll come back on 8/22 at 9 a.m. I'm 8/24, excuse me. Thank you, Madam Clerk. August 24th.
All right. If they find anything.
I'll let you know. Yeah.
Cool.
Dallas Francis.
Casey Etheridge for Dallas Francis, and we're here in 2022 CF 1597. If I may have one moment, Your Honor.
Where are you located primarily?
Judge, I'm in the Fort Walton office right now.
Very good.
Okay. We may proceed, Your Honor. I guess we're entering a plea of not guilty for today, but I think the state has filed a motion that he would like addressed.
That's correct, Your Honor. Yesterday, I filed into this case a motion to change venue to Walton County. That motion, sorry, I'm just pulling it up briefly.
Be so far away. I'm not worried. How are you doing?
Your Honor, the allegations against Mr. Francis relate to a flight from law enforcement that originated in Walton County, went through Holmes County before ultimately concluding in Okaloosa County. Based upon that, pursuant to Section 910.05, it would be my argument for the court today that this case may be prosecuted in any of those counties. The state does intend to prosecute this matter in Walton County and is therefore asking the court to transfer this matter to that jurisdiction, Your Honor.
Your Honor, we received this motion and have done research on everything to make sure, of what we're arguing today, and we have no legal basis to argue against this, so.
Very good. The court will grant the motion to change your venue.
Thank you, Your Honor.
Okay. What does that do as far as him being in jail? Do they transfer him over to, how does that work?
So, Judge, what I'll do is draft a proposed order for the court that will lay out some of the procedural requirements. Among those, the clerk will need to send over a certified copy of the minutes from today's hearing, a certified copy of the record, I believe. Once that's done, Walton County accepts the case, then I believe at that point, the Walton County Sheriff's Office can come and pick Mr. Francis up.
So they'll put him in, house him in the Walton County?
Correct, Your Honor.
Okay.
So I assume, Your Honor, that I guess, since we can't technically have that on the record today, I assume we need to enter a plea of not guilty and set this on the pretrial conference date as like a status, just to make sure he goes over.
I think it's a good idea. So we'll enter a not guilty plea today, and we'll schedule it in this docket for 8/24, 9 a.m., just more of a status conference for where we're going with everything. Okay, very good. Thank you very much.
Thank you, Judge. That is my only case on the docket, if I may be excused.
Glad to have you.
Thank you, Judge.
To go out and swim to your car.
Try and stay dry.
Good luck. Gerald Gundy.
Still, I'm saying here either, so.
No attorney on Mr. Gundy. Come on forward, Mr. Gundy. Okay. The state announce.
Your Honor, Mr. Gundy is before the court on 22 CF 1488. He is charged with possession of a controlled substance and possession of drug paraphernalia.
Mr. Gundy, you do have a right to an attorney with this. You wish to have an attorney appointed?
Yes.
Court will appoint the public defender. Court's going to issue a not guilty plea on your behalf.
Yes.
Come back on 8/22, 22nd of August, 9 a.m., okay?
Yes.
Meet with your attorney in the interim, get a card or something, okay? Chevy Henderson. State.
Mr. Henderson is charged under 22 CF 1555 with 1 count of possession of controlled substance and 1 count of possession of drug paraphernalia.
Okay. Mr. Henderson, again, you do have a right to an attorney. You wish to have an attorney appointed?
Yes, sir.
Okay. Court will appoint the public defender. Court's going to issue a not guilty plea and come back on 8/22 at 9 a.m. James Jaggers.
Casey Etheridge for James Jaggers, and Your Honor, he would like to enter a no contest plea today and accept the state's offer. It would be count 1, adjudication of guilt, credit for time served, $515 in court costs, $100 cost of prosecution, $150 public defender fees, and count 2, adjudication of guilt, credit for time served. And I apologize, that's in 2022 CF 1624.
Very good. Jaggers, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. You can put your hand down.
Okay.
You heard your attorney state the terms of your plea agreement. Is
Yes,
that
sir.
your understanding of what the plea agreement is?
Yes, sir.
And then you're in agreement?
Yes, sir.
I see the same thing is written down in this, in the written plea agreement. It's got your signature on it. If you've gone over this plea agreement with your attorney, made sure you had all your legal questions answered.
Yes, sir.
Okay. You're entering this freely and voluntarily? You're
Yes, sir.
entering this plea freely? Okay. And you understand this is the final resolution of your case? Is completed?
Yes, sir.
Totally? Okay. Very good. Based upon that, the court will accept your plea. Will be an adjudication of guilt, credit for time served, fees and costs. How long does he have to pay the fees and costs?
180 days?
180?
Did I not put that on there? I
Yeah.
apologize.
So you got 180 days to pay the fees and costs. If not, it'll go to collections.
Yes,
But
sir.
you'll be able to get out today probably from jail.
Yes, sir.
Any
Appreciate it.
questions?
No, sir.
Okay. And the defense in agreement as to the score sheet?
Yes, Your Honor.
Okay, thank you. Thank you. Bless you. Thomas Johnson. Did the state announce?
Thomas Johnson is before the court on 22 CF 1623. He is charged with possession of controlled substance and possession of drug paraphernalia.
Okay, Mr. Johnson, you do have a right to an attorney. You wish to have an attorney appointed?
Yes, Your Honor.
Court will appoint the public defender. Court's going to enter a not guilty plea in your behalf. We'll come back on August 22nd at 9 a.m. Make sure and get a card so you can set an appointment with your attorney, figure out what's going on, okay?
Yes, sir.
Okay, thank you. Corey Jones. Okay, that's great. Thank you. That's right, thanks. Roger Lee.
Twenty-two CF 1660.
And Judge, Mr. Lee's in custody. He's going to need to look at the plea agreement, so we could skip him. Call him back later. Yeah.
We'll hold on him? You want to
Yeah,
hold?
hold him and then pass him for now.
Yeah, we're going to,
Go ahead and go back, because I'm going to send you the written agreement.
yeah. Damian Mitchell.
Judge, I don't think they're going to have Mr. Mitchell. I think
Not
he's in
in,
the,
I don't have him down.
he's in the Escambia County Jail.
And Judge, the
Okay.
state has not filed an information yet. If we could just reset this for the next.
Okay, so if we don't, generally the rule is give them one more time and then it'll be dismissed if it's not. Is that how?
No, Judge, we have 175 days to file
175.
file the information. In this case, I'm waiting on a witness statement and his prior JNS. He's arrested for driving while license suspended third or subsequent. So I'm
Okay.
just waiting to confirm that.
So when do you want to come back on the,
If we could put it on the 25th, is that a plea day?
yes, it is.
I think that would be sufficient time.
August 25th at 1:30. Continue the arraignment. Morris, Monica Morris.
Judge, I see that that case is closed. A null pros was filed on June 24th, but for some reason, my notes indicate it's still open on the clerk's site. Not sure if they received the null pros form or not.
It's 22-1550. Okay, so you'll close it and all? Okay. So- Okay, so it's no pros, we're good. Thank you. Latoya Nelson.
No response, Judge. I'm showing she was released June 24th on a 1,500 signature bond. State would ask for a KPS with no bond.
Okay, court will issue a KPS. Samantha Packard. Inmate, we've got listed.
Judge, I received an email this morning, I forget who it was from, saying to remove her from the docket today.
Okay. So, Mr. Russell, this year's, you entered a not guilty?
Actually, Judge, we withdrew, so I'm guessing RCC.
ORCC? Okay. So not guilty entered, and we'll come back on 8/20. Is she in jail? Yes? She's still in jail? Okay, so we'll come back on 8/24. Oh, I didn't realize. That's all right. Okay, so you got it and all that. Okay, good. Tosha Pertusit. If I said, did I say that right? Tasha Pertusit. Okay,
It's 22
sorry.
CF 1634, Judge.
My case, Judge, at this time, we've been provided information. We'll enter a plea of not guilty. Request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty plea. We'll come back on August 22nd, 9 a.m. Be in touch with your attorney. Lawrence Rudd. Rudd.
I'm not sure, Judge, it's spelled two ways. I think the jail has him under Rudd, R-U-D-D, and I think the clerk has him under R-U-U-D.
How do you pronounce your what's your spelling of your last name? R-U-U-D? How do you pronounce it?
Rudd.
Rudd.
Okay. Judge, in Mr. Rudd's case, we've been provided information. At this time, we're going to enter a plea of not guilty. Request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter not guilty, and we'll come back on 8/24 at 9 a.m.
I'll come out and see you. Okay.
Gregory Siegel with the ORCC is Ms. Flowers.
That's another one that was taken off the docket, Your Honor.
Was it? Okay. Was it not guilty plea file? Okay. And then Angela Taylor, also ORCC, did you not guilty on that one too?
Yes, Your Honor. I was just they were filed late yesterday.
Sure. Okay. We got them. And we're coming back on both of those for 8/24 for the inmate and 8/22 for Ms. Taylor. Okay, I think that's all of the ORCC except the one at 2 o'clock. Triplet, Mr. Russell.
Charles Russell, Public Defender's Office, William Triplett, case number is 22CF1604. William Triplett, no response, Judge.
Judge, my notes indicate he was released on a $2,500 cash professional bond on June 21st, 2022. State would ask for a capias with no bond.
So ordered, no bond. Varvel. Susan Varvel. Did I pronounce that right? Yeah, it's bad out there.
This is 22CF1547. Ms. Barbell's been charged with 1 count of controlled substance and 1 count of paraphernalia.
Okay. Take your time, ma'am.
So sorry, my shoe broke
That's
when
all
it got
right,
wet.
that's all right. Ma'am, I don't know if you heard my statements at the beginning, but
Yes, sir.
you do have a right to an attorney.
Yes, sir.
Okay, you want to have an attorney appointed?
Yes, Your Honor.
Court will appoint a public defender. Court will enter a not guilty plea on your behalf. If you'll come back on 8/22, meet with your attorney in the interim. Yes.
I got a notice in the mail that I already had a pre-conference on August 10th. It came in the
Not
mail.
this case. Is there something that went out in this case? Do you have any other case?
No, sir. I've never been arrested before.
There is no pretrial. Is there an August 10th? Is that South County or something?
I think that was-
Is it possible?
Didn't bring the paper with me. I should have.
Well, once you do this, when you go home, read it again, and maybe when you talk with your attorney before August 10th, maybe show it to him or talk to him even before the 10th to make sure there isn't something you're supposed to go to. I don't want you to get picked up based on some mistake or confusion. But in
Yes.
this case, August 22nd.
Yes, sir. I'll be here.
Okay?
Thank you, sir.
Jolie Waddle. All right. Waddle?
Oh.
It's all right.
Charles Russell, Public Defender's Office, Judge, that's my case. Case number is 22CF1525. Jolie Waddell. No response, Judge.
For issue capias, no bond. Julius Wilkes.
And, Your Honor, if we could recall Jolie Waddle, I'm also showing this person has an arraignment for August 4th on a separate case. I'm guessing they're not in jail, but do we leave them on the docket for the 4th? Do you want to leave them on?
I would like to leave that one on the 4th in case she shows up. And then if she does, then maybe we can deal with the capias in this case and
Okay.
Yeah, I mean, it's
get it straightened out.
very possible that she thought that's what she was supposed to go to, and she shows up then, maybe we can deal with both of them.
Judge, this is Julius Wilkes. Case number is 21CF1245. At this time, we've been provided a copy of the information. We'll enter a plea of not guilty. Request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter a not guilty plea on his behalf. Come back on 24th of August at 9 a.m. Okay? Jeffrey Willis. That's jail.
He's in jail. Charles Russell, Public Defender's Office. Judge, this is case number 22CF1565. Jeffrey Willis, we've been provided a copy of this, the information. At this time, we're going to plea of not guilty. Request trial by jury, 15 days to file any pre-arraignment motions.
Very good. The court will file a not guilty plea on behalf of the defendant. We'll come back on pretrial on August 24th at 9 a.m. Okay? Joshua Willis.
Charles Russell, Public Defender's Office. Judge, this is Joshua Willis, present and approaching. Case number is 22CF1541. State's filed an information. At this time, we're going to enter a plea of not guilty. Request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty plea and we'll come back on August 22nd at 9 a.m.
Thank
Stay
you,
in
Judge.
touch with your attorney. Okay, I think that's all of our arraignments.
And Judge, I'm going to go talk to a couple
Sure.
of people.
Okay. Mr. Durrell, where'd Dustin go? He was just here.
Right here.
Oh, there he is.
I'm sorry, Judge, I was blocking this.
That's all right.
Thank you, Your Honor.
You want to do Lush first?
Your
Yeah.
Honor, I believe I'm speaking with Ms. Glisson, if I can just have a moment to go over the final.
Okay, we'll pass Lush and we'll,
And, Your Honor, I believe Mr. Santillan, that motion is moot at this point. The state filed an amended information.
right. I saw that. I didn't know if that corrected it, so I just kept it on the calendar.
Yes, Your Honor.
Okay.
So if I may just pass Ms. Lush, and I guess we'll set Mr. Santillan.
On the motion to dismiss, how do we want to deal with
You can
it?
just enter an oral order striking the motion.
Okay.
As moot. I agree with that.
It's not necessary because of the amended information.
Yes, Your Honor.
Okay, very good.
Thank you.
So we'll pass over, just let me know when you're ready on that, and we'll come back.
Thank you, Your Honor.
Okay, thank you. Okay. Mr. Moore, Carl Domino.
Yes, sir, Your Honor. Mr. Domino is present, Your Honor, hopefully. Apologize for being more disheveled than normal, Your Honor.
All just a matter of degree, Mr. Moore.
It's always a matter of degree with me, Your Honor.
I'll tell you, anybody just waded through that thunderstorm out there should be commended just for getting here.
Your Honor, this matter is scheduled for the 4th. The state and I have been in discussions. I think we will have it resolved on or before the 4th.
Okay.
So there were no subpoenas for today because we understood it was be for the 4th anyway.
Okay.
And so.
So what are we doing on the 4th?
Is either entering a plea or having the motion heard.
The bond motion?
Well, and I think
Which
that
motion?
motion to suppress most importantly.
Okay. We need to make sure and reference that, the motion to suppress
Yes, sir.
on August 4th.
Yes, sir. But, Your Honor, I think, based on some important discussions I with the state, we may have it resolved by plea on that day.
Okay, well, that's fine, but we just need to make sure, as far as the prep, as far as I'm concerned, I have
Yes,
to
sir.
prep them, so.
Yes, sir, that would be on the motion to suppress. There's two matters pending. One, Your Honor, the motion to suppress relates to the drug trafficking and possession
Right.
case. The other matter is, I haven't filed a motion to that one yet.
Okay, very good.
Okay?
Okay.
So, Judge, I will see you on the 4th.
4th of August.
Yes, sir. Yes, sir.
Okay.
Thank you, Your Honor.
And that's at 2 o'clock,
Yes, sir, 2 o'clock.
right?
Okay?
Madam Clerk?
Thank you, Your
Okay,
Honor.
thank you very much. Okay, Cusimano, Ms. Flowers?
Your Honor, for the record, this is Miss Gwendolyn Ruth Cusimano. We've reached an agreement with the state. We're here on 22 CF 1399. I have a copy of the plea agreement. Let me make sure it's signed by everybody. Oh, state.
Thank you. You pronounce it Cusimano? How do you pronounce your name?
Cusimano.
Cusimano. Would you please,
Sorry.
would you please raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So Ms. Flowers, would you announce the terms of the plea agreement?
Yes, Your Honor. Ms. Cusimano would like to plead no contest as charged in the information. The terms of the plea would be an adjudication of guilt, credit for time served, $515 in court costs, $100 cost of prosecution, $150 cost of defense, and monies to be paid within 180 days, and then to collections.
Very good. So, and that's the state's agreement.
That's correct, Your Honor.
And I'm looking, Ms. Cusimano, at the plea and sentencing agreement, and it references the same plea agreement.
Yes,
So I
sir.
see you've signed it. So am I to assume, or did you have a chance to go over this in detail, make sure you understand all the legal ramifications?
Yes, sir, I do.
Obviously, this is, this is a good deal in the sense that there's no probation, no jail time, but it does have a legal effect on you, and I want to make sure you understand, how it works for you. So.
Yes, sir, I do.
Credit for time served, obviously fees and costs payable in 180 days, and there is an adjudication of guilt that will be on your record. Do you
Okay.
understand all that?
Will
Question?
I be leaving today?
I'm sorry?
Will I be leaving the jail today?
I believe you'll be leaving jail.
Thank you.
I think they get them out on right on. Believe me, they don't want to keep you around if you're not
I
supposed to
don't
be
want to be
there.
around.
I
Thank
understand. I mean, the feeling's mutual. I mean, they have plenty of uses for the space, unfortunately. So.
Yes, sir.
But no, you'll be out today. So.
Thank you so much.
Very good. So you understand this is the final resolution of your case?
Yes, sir, I do.
Okay. Very good. Based upon that, the court will accept your plea and will adjudicate you guilty. You'll get credit for time served and the fees and costs that are contained in the plea agreement.
Thank you, Your Honor.
You'll have 80 days, and then it'll go to collections.
Thank you, Your
Okay?
Honor.
All right, good luck. And this defense is in agreement as far as the.
Yes, Your
the
Honor.
score sheet.
Defense agrees with the score sheet.
Thank you.
Thank you.
William Jensen.
Yes, Your Honor, for the record, this is Mr. William Thomas Jensen. We're here today on a violation of probation. We're set for an evidentiary hearing. However, there's a couple of matters that we need to address with the court prior to having the evidentiary hearing. Your Honor, first of all, Mr. Jensen has, I don't know if he's filed it with the court. He's indicated to me that he would like a change of venue. Based on his belief that he doesn't believe he can get a fair and impartial judgment from the court in this matter. This is based on what he conveyed to me as some statements, rumors really, that Your Honor is biased towards sexual offenders. I told Mr. Jensen that I did not have any evidence, nor was aware of any evidence supporting any claim of bias of the court, and could not, therefore not in good faith, file a motion to change the venue.
Have you filed something, Mr. Jensen?
I don't know how.
He wanted me to file something on his behalf, Your Honor.
Okay.
And I had told him that I, didn't have a good faith basis to do that, and, based on that, we talked about either, second of all, I had discussed with him the state's offer, which the state had made a generous offer of 5 years DOC to resolve this VOP, as well as his new law, which is a failure to register third-degree felony. I spoke with him about his exposure on this VOP alone being around 13 years, because he would lose his gain time if he was sentenced. And I urged him to accept the state's offer, that it was a good offer, but he stated that he did not want to accept the offer and did not want to have a hearing. And I kind of explained to him it kind of had to be one or the other, but he wanted a chance, and I wanted to give him the chance to express his grievances to Your Honor and let you make the decision on whether to go forward with the VOP hearing. He, of course, feels that there's some sort of conflict with me, but, I explained to him I have to do what I believe is right legally. I understand his views as wanting the change of venue, but there's just not that evidence and basis to support, I don't believe. So did you want to address the court, Mr. Jensen?
If you don't mind.
Sure. Would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
Would you do me a favor and talk into that mic for me so I can hear you? Good. Okay.
I'm going to
Jensen,
read it.
what, you have the floor.
I'm going to read it because I'm
Sure, that's fine.
confused. Sir, the plea form that I signed is not what I was charged with, so it is null and void. 794-011 was what I was arrested under, but 777-04 was what it was dropped to.
Hold on a second. Could you explain to me, I just thought you were wanting to have a change of venue.
Yes, sir.
You just seemed like you were launching off on a plea form, and I'm just wondering, I just wanted to make sure you're arguing for a change of venue. Is that what, I didn't follow, I wasn't following you. You seemed like you were going in a different direction.
Yes.
I just wanted to make sure I understood what you were referencing.
What I'm referenced to is the VOP stems from the original charge.
Okay. Did I do the original charge?
No, sir.
I
That was
didn't accept the plea agreement?
No, that was Judge Remington.
Okay. I didn't think I did.
Yeah.
Okay.
I didn't mean to confuse you. I'm just.
That's all right.
I've been trying to get somebody, to help me explain this because I feel that I was mistreated, first of all, when I was threatened into taking a plea. And I just wanted to let you know what I've found out since I've been back in jail.
Okay.
If I may.
I'm not sure
may I
I'm not sure I'm
clarify?
following you, but I'll let you talk.
If I may clarify what we talked about, Mr. Jensen believes that his original plea was coerced or that he did not plead to the correct charges. However, I have spoken to him, again, just to clarify for the court, that we are not here to address the original plea, 17 years ago. He's been incarcerated, he's been in DOC 17 years serving time. He was sentenced to 20 years. On the charges. He believes and has, expressed to me, and I have told him, this is not what I'm here to help you with. We're here on a VOP, which is the allegations are that he cut off his GPS monitor. And so I've explained that to him, but he seems to.
Well, I'm just going by what the law says.
Okay.
What I was trying to explain is the original charge.
Let me make sure and explain something to you before you launch off on this. This is being recorded. Do you know that?
Yes, sir.
Okay. And, one of the Miranda rights, we all, you see on TV, anything you say can and will be used against you in a court of law?
Yes, sir.
You understand that by this recording, the state and any proceeding going forward, you're under oath, you're being recorded, and it can be used against you. I don't want you to incriminate yourself, because you have an absolute right under the U.S. Constitution not to incriminate yourself. You're voluntarily wanting to talk, and I'm going to let you talk, but I want you to know, and I'm guessing your attorney is maybe suggesting you don't talk because you could incriminate yourself. But if you want to talk, I will allow you to talk. But I just wanted to make sure and say, do you understand that?
Yes, sir.
Okay. Go ahead.
Can we start over?
You can start over. Yeah, go ahead.
The plea form that I signed is not what I was charged with, so it is null and void. 794.011 was what I was arrested under, but 77704 was what it was dropped to. The plea form that I signed was 794.011 and 800.04. That's double jeopardy according to the Florida law. Even 794.011 and 800.04 has to have injury to the victim. So what I signed is illegal under what I feel and by the law. That's all I have.
Okay.
And the VOP and the ankle monitor is under the original arrest. So I've been told by a couple public defenders.
I don't really know exactly where to go, but I'm going to ask the state to comment.
Judge, our score sheet reflects that he pled to 2 first-degree felonies, lewd lascivious molestation, offender 18 or older, victim less than 12. That's an F1, L9. He also pled to sexual battery 794, 011, but it was under the attempt statutes. That might be what he is also referencing. That would also make it a first-degree felony, level 8. We are here today for the evidentiary hearing.
What was the max sentence on those two?
Judge, originally his maximum liability was 60 years. However, he pled to 2 concurrent first-degree felonies, and he did 20 years, which comes out to about 17 years of gain time, followed by 7 years of probation, or 7 years of CC or sex offender probation. So essentially, defense and I believe his exposure, additional exposure, comes out to about 13 years in this case. There's also a new failure to register as a sexual predator case. That's a third-degree felony. That's an additional 5 years of exposure.
That's outstanding as well, right?
Yes.
So where are we going here? I mean, look, I'm not taking any action on his verbal extemporaneous request. If you feel that there's some post-conviction or something that you want to file, you need to file it. I'm not going to just, hear oral arguments without the state being able to respond to it. It's not the way it is. So,
Yes.
I appreciate what you said. I'm not taking any action on it because it hasn't been filed. And so I don't want you to think that, I'm not even denying it. I'm not even considering it because it hasn't been filed. So.
I tried twice to get my, hang on, let me think of the word, all my papers, we call it,
Your file?
Your discovery?
discovery. I've tried twice to get it. My girlfriend come down here to get it. They won't give it to her either. I got a 2254 form.
Well, we're here on a violation, actually was not a violation of probation, a violation of community control from back almost a year ago. So the question is, and I know it was delayed significantly because there was a mental health evaluation and it was found to you. I actually read it before we came in here today. And, you're sound and ready to go, cleared as competent to proceed. And so, based upon that, we're gonna proceed on the violation of the community control. So, I know today was scheduled to be an evidentiary hearing. I'm not gonna press everybody. Where are we at as far as,
Judge,
are we
because
ready? I'm not assuming, are you ready to go today?
we are ready to go, but since the state sent the evidentiary hearing ourselves, we would just need Mr. Jensen to formally reject our offer, and we have our officers ready here to proceed.
Can I have a moment to speak
Sure.
with my client? Okay.
Matter of fact, if you need to, Ms. Flowers,
Yes, Your Honor.
if you need to talk with him and don't feel like he's pressed, I'm willing to pass over this and let you chat with him and.
That would be, I would like that if you would.
Let's do that. I don't want anybody to feel rushed on this. So we'll just pass over this. We'll come back to it. We're not
Thank you, Your
gonna,
Honor.
sure. Okay, which one are we? Okay, yeah. Lush, yeah.
Your Honor, we do have a written plea agreement, if I may approach.
You may. Thank you. Thank you. Defense in agreement on the score sheet?
Yes, Your Honor.
Okay.
Your Honor, at this time, Ms. Lush would withdraw her previously entered plea of not guilty and enter a plea of no contest as charged, with the understanding she would be sentenced to 24 months of drug offender probation, fines and costs in the amount of $1,440, and that is, I've included the $500 fine in that one, Your Honor. So if the clerk needs to split them out, it's $940 for court costs and $500 for the fine. $100 cost of prosecution, substance abuse evaluation, and any recommended treatment, and random urinalysis, Your Honor. I did include on the plea form that Ms. Lush travels frequently for work, specifically to New Orleans, but I know she does Tampa, Jacksonville as well. I've spoken to probation. I believe they said they would be able to issue a permit. I just want to make sure the court has no objection to that. And of course, she'll handle all that through probation at the time. But if the court is comfortable saying no objection to that.
I'm okay. I just want to make sure that probation is,
If she is current on her conditions of supervision, we'll issue her a travel permit.
okay. So the main thing is that, ma'am, you're going to have to make sure to stay in good contact. That you just can't, you can only go with the approvals and whatnot. So you're going to have to really abide. It's going to be really a burden on you to make sure and follow through with these things to make sure you're not in violation. So, but you can do it if you want to, and we want you to stay working. And we're not trying to eliminate employment. So anyway, ready? Stay in agreement with all that?
Yes, Your Honor.
Okay. Ma'am, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So you heard your attorney state the terms of the plea agreement, and I see that plea agreement is contained in the plea and sentencing agreement. Is that your understanding of the plea agreement, and are you in agreement with it? Yes? And I see you've signed it. Have you gone over this plea agreement and really made sure and had all of your legal questions asked of your attorney about what it means to you legally and how this whole process works?
Yes.
Because importantly, you're waiving some very valuable rights by entering this plea agreement here today. You're waiving the right to go to a trial, the right to confront witnesses, the right to force the state to prove their case beyond every reasonable doubt. You're waiving those by entering into this. Do you understand that?
Yes.
And do you believe it's in your best interest that you do that?
Yes.
Okay. Nobody threatened or coerced you to get you to enter into this?
No.
You did so voluntarily?
No, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement and will, there'll be an adjudication, no contest, with withhold of adjudication as charged, 24 months drug offender probation that has certain requirements. You need to make sure and coordinate good with the probation officer to make sure you follow those. And perhaps the most important thing is the substance abuse evaluation and following the services that are recommended. Hopefully that'll, make this bad event maybe turn into something positive. Okay, but it's important you do that and do it quickly because you need to do that during the course of your probation so you can complete your probation on time. Okay, do you have any questions regarding this?
No, sir.
Okay. That is true. It doesn't say that in here. But generally speaking, the paraphernalia, we've just been doing credit for time served, state? Credit for time served, okay. If you'll just put a credit for time served as to count too. That's all right. That just means you don't have to really, you're already, credit for time served means that's already been disposed of. Okay, thank you. Any questions, ma'am?
No, sir.
Okay, thank you very much.
Thanks.
Talk to probation over there. Go talk to them. I think you're good, Mr. Drell.
It was a withhold. I don't think she needs to.
Withhold. It was a withhold.
Yeah, right there. Thank you, Your Honor.
Thank you. Okay. English?
If we can pass on Mr. English, I think we have a agreement almost 98% complete. I'm just
Okay.
making sure we have all-
So we've got, we've got Jensen and English are the last two. I can wait, I mean, I'll go back to my, so Jensen, they're still working on it? Okay. Jensen's still out with Ms. Flowers? Okay. We're going to take a break. I'm going to, we've got two cases, they're both talking to them. So just call me. I'll be in my office.
All rise. May be seated.
Want to do first? Jensen or got Mr. English, Miss English? Go ahead.
Yes, Your Honor. We and Mr. Jones, we have reached an agreement. I've got the plea.
Thank you. Thank you.
For the record, this is William Thomas Jensen. We're here today for a VOP evidentiary in 2004 CF 1027. However, we have reached an agreement with the state that will be encompassing the VOP as well as Mr. Jensen's new law violation, which is 21 CF 2269. Mr. Jensen wishes to admit the violation in 2004 CF 1027. The terms would be an adjudication of guilt, revoke and terminate probation, sentence him to 5 years DOC, waive prior credit from the original sentence served in that case number, a $100 VOP fee, a $150 cost of defense. And then in 21 CF 2269, Mr. Jensen would like to plead no contest. Terms of the plea would be an adjudication of guilt, 5 years DOC concurrent with the sentence in 2004 CF 1027, 515 in court costs, $150 cost of defense, and all monies to be sent to collections.
And just by point of clarification, when he gets out of DOC, no further probation, the remainder of the probation, well, it says revoke and terminate probation, so that's ended.
Yes, Judge, that's correct. And
Hold on a second. Probation had,
Probation, Your Honor, but if he comes out on conditional release, on a release program from the prison, he's going to be hooked back up on GPS and have to go through all these same stuff that he obviously didn't want to do. So we can't control that. The prison puts them out on conditional or controlled release.
just want to make sure, do you feel like you need to go over that with him? What he's,
do you understand?
I understand it, but I thought this took care of all that.
You won't be on probation, but if you're on conditional release, you will be on a GPS monitor. Does that change your?
You're going to do what you're going to do.
I believe he still would like to enter the plea.
appreciate that clarification. That's important. We want to.
It's not technically probation, but if he gets out of prison early.
Yeah.
Whether if it's a week early, it'd be on 7 days of GPS conditional release.
Well, it's important, you know, no matter, you got to, when we're laying these things out, you deserve to have it explained to you in detail so that you can make an informed decision with legal counsel, with, you know, to determine whether you want to proceed and how you want to go. That's one of your rights. That's my job here, is to preserve that, okay? So, would you please raise your right hand?
Sorry, could I clarify with probation too?
Sure.
Would you mind? So you said if he's, so he'll just be on the GPS monitor until his sentence is up.
Correct.
So that's until the 5 years is up. So if you get out, if you serve the 85% with your gain time, you'll be on the GPS monitor until the end of that 5 years.
That is correct.
I just want to make sure he understands and I understand. Does that change your wanting to plea?
Guess not. I have no idea.
You have to make it clear on the record that you want to enter this plea and that you're not. I'm not pressuring you. The court's not pressuring you, but you have to make that clear on the record if you want to take the plea.
I don't want you, I know you kind of feel like, well, I don't want you to feel coerced on. I mean, we can come back on this and, you know, make sure you are comfortable with it. I really, I mean it sincerely, not trying to twist your arm, coerce you in this.
Well, it's probably not going to change if I come back, so.
You always have a right to go to a hearing, you know, I mean, you have a right not to enter into this plea.
If I have the hearing, it's going to be a lot more than 5 years, from my understanding.
Then what you're saying is this, in your opinion, this is the best situation for you. Another way of saying it, I don't want to put words in your mouth, but if you believe that a hearing would end up, you know, worse result than a plea.
And that's what I've counseled him as to his maximum, which would be far greater on just the VOP alone. And I have instructed him, because I understood what the court said earlier, that since we were set for the evidentiary hearing today, we would go forward today. So I believe this offer is only on the table today.
That's correct.
Boy, got me all the way around, didn't you? Well, let's do it. Get it over with.
Okay. Did I swear you in?
While ago.
Well, let's do it again. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, with the clarification that was just made by probation, as far as any type of conditional release, and the explanation of your attorney as to what the plea agreement is that your understanding what the plea agreement is? I'm looking at the plea and sentencing agreement as well.
Yes, sir.
I see you've signed the back of it, and I assume you've gone over in detail what this plea and sentencing agreement means.
First time I've seen it, but
I mean, do you have questions about it? You need more time to go over it?
no, let's go.
You sure?
Yes, sir.
I'll give you more time.
I got it. I understand.
Okay. So the core of this is the 5 years, Department of Corrections on both the VOP as well as the new law charge. They would be served concurrent, but you would not get any credit from earlier. So this is basically 5 years going forward.
Yes,
No
I got
credit,
it.
no credit for time served on your earlier, the 20-year sentence or anything else other than, earlier than this. Do you understand that?
Yes, sir.
That's an important issue. Obviously, it's basically 5 years going forward, but when you get out, probation will be revoked and terminated. So you're not going to come out on any probation, although there may be a conditional release, which has some of the hallmarks of probation, such as a monitor, but it's not the same. Okay? You understand that?
Yes, sir.
And you understand that, the fees and costs would be, how are we handling those as far as, they just go to collections?
Collections, I believe it's on there. If it's not on there, was the intention to send them to collections.
What does that mean?
It doesn't say that. Yes, it does. All outstanding monetary amounts will be sent to collections. There'll be something on it's just like if you don't pay a credit card and they charge you and they say, you get a lawsuit and there's a judgment that says you owe $1,000 on your credit card. That's what happens. Some will be on your record.
Cost, it'll be against your license, so when you get out, you would have to pay the court cost before you can get a driver's license.
Clear?
Okay? You understand that?
Yes, sir.
Okay. So, did you have, I know we took a break during this period and you got a chance to meet further with your attorney. Did you get all your questions answered regarding this plea agreement? Even though you may not agree, you'll agree with everything, but you may not like everything, you'd want a different result, but I want to make sure that you've gotten all your legal questions answered, and you're making an informed decision.
The only thing that I'm concerned about, probably not dealing with this, but I've tried twice to get my discovery. I need that to file my 2254. My girlfriend's even come down here and they won't give it to her.
Okay. All I would say to you is we're not here on that today.
I understand.
Okay.
That's the only issue I have.
Okay, well, that's not an issue today. That's not interfering with your wanting to go forward with this, is it?
No, sir.
Okay. You understand that by entering this plea here today, this is important. This is a final adjudication of this new law charge and the VOP. It will greatly reduce your opportunity for any type of appeal as to those two things. Do you understand that? Okay. I mean, there are some, only a very limited amount ability. On a normal case, you can always appeal it. You can go to a verdict one day and appeal it the next. Everybody has a right to do that. By entering this plea agreement here today, you limit your right to do that in these two situations. Do you understand that?
I do now.
Okay. Does that change anything for me telling you that?
No, sir.
Very good. And the state's on board, in agreement on this.
Yes, Your Honor, and I believe was there a score sheet submitted as well?
Yeah.
Okay.
Defense is in agreement with the score sheet.
And
It is a downward departure based on a negotiated plea.
so it's a downward departure. So this plea agreement is less than your sentencing guidelines, minimum sentencing guidelines. Doesn't mean they couldn't change, but just so you know, there is what's called a downward departure. So, okay. Based upon that, the court will accept Mr. Jensen's plea here today. Will be an adjudication of guilt on the new law charge and admission of the violation of probation. And the court will sentence Mr. Jensen to 5 years in the Department of Corrections starting today. No waiver. There will be a waiver of prior credit for time served. And both of the 5-year sentences for DOC will run concurrent at the same time, VOP and the new law charge.
Ron, I just wanted to clarify, because you
Sure.
said starting today, and actually, I think we are okay with him getting credit from when he was arrested on the VOP. He's waiving prior credit on
Okay,
the
waiving prior
original
credit
trial.
from the original.
The original
20
20 years.
Yes,
Yes,
he
Judge.
will have credit from.
Thank you. That's good. Not trying to take anything away from him. Okay. Very good. Anything else? Any other questions, sir? Any other questions?
Nothing. I got
Okay.
a couple to her, if that's okay.
Sure. Thank you very much.
Carol, right? Thank you, Judge. That's all I've got.
Yeah, but go ahead. Sure. Yeah, I'm on the clock, so.
Okay. Miss English, DeAndre
It's Mr.
English.
English, Judge.
You dry off a little bit? That was a gully washer. I'm telling you, I looked out the window, I couldn't believe it. You can't hear it on the second floor at all, but on the third floor, you can hear it on the roof.
My second shower of the day. He was. If this is still what you want to do, you need to sign at the top. Can you reach it? Judge,
Couple of 22nd.
Judge Rudy Harper on behalf of DeAndre English. He is, sorry, I'm trying to unroll these by rolling it the opposite way. He's before the courts on a violation of probation that was set for a sentencing hearing today. However, the state and I have come to an agreement to resolve both the possible sentence with respect to the violation of probation, as well as the pending new law violation that is not on today's docket, which is 21 CF 1858. It's a home invasion robbery conspiracy offense. If the court would permit a plea to both, the proposed sentence is an adjudication of guilt, 36 months Department of Corrections to run concurrent, credit for all time served, revoke and terminate supervision in 20 CF 1322, which is the violation of probation case. Costs in that case will be sent to collections. On 21 CF 1858, which is the new law charge, that will be followed by 2 years of probation. Have no contact with the co-defendants, have no contact with the victims, undergo random year analysis, $615 in court costs, $150 cost of defense, and $5,958 in restitution, which is joint and severable with the co-defendants. Your Honor, this would be a stipulated downward departure in return for a plea. Your Honor, if I may approach.
You may.
And Your Honor, this also, it is a legitimate uncoerced plea bargain, but also the fact that this defendant was an accomplice and was a somewhat minor participant in this. He is charged with a conspiracy to commit in the 21 CF 1858. So that's also the other reason that's checked for the downward departure box.
Okay. And is the defense in agreement with regard to the score sheet?
Yes, Your Honor.
And so the minimum guidelines is 46.875, almost 47 months, correct?
With the new law incorporated in, yes, Judge.
Right. Okay. Mr. English, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your agreement. Is that your understanding of what the agreement is? And I'm looking at the plea and sentencing agreement that does appear to have your name on the back of it signed. So did you sign this plea agreement? And did you go over it, hopefully in detail with your attorney, make sure you had all your legal questions answered about this plea agreement? Because this is an important step. By doing this, you're essentially waiving some valuable rights. You're waiving the right to go to a trial, to force the state to prove their case, to confront witnesses, all those things you're waiving. You're also limiting, by entering in this, you're dramatically limiting your ability to be able to appeal this. There are some limited situations, but as a general rule, in a regular case, you can appeal anything, right? When you enter into a plea, it dramatically limits that. Do you understand that, and have you kind of been able to ask any questions of your attorney that you want to ask regarding things like that? I'm asking you some legal questions. If you want to pause and ask him any questions, you're welcome to. I'm not trying to put you on the spot. I just want to make sure two things. I want to make sure you understand what the plea agreement is, and that you're entering the plea freely and voluntarily. That's why I'm asking all these questions. Okay? You need to ask your attorney anything? Okay.
He just had some minor questions about the appeal process and what those limitations may be.
That's good. If you have any other questions during this that I prompt by my questions, feel free to just, let me know, and I'll let you speak with your attorney privately, okay? So, one important thing, question I have for defense counsel, is there a factual basis for the entry of this plea agreement?
In return for a downward departure and for a plea to these terms, Judge, yes, he's going to be entering a plea of no contest as to both of these cases.
Okay, very good. And do you have any further questions regarding this plea agreement? Did anybody threaten or coerce you to get you to enter into this plea? Anybody promise you anything other than what's contained on this plea form? Do you feel like you've gotten good legal representation in this matter? Very good. Based upon your testimony, the court will have an adjudication of guilt and in the new law charge. You'll get 36 months in Department of Corrections on both the VOP as well as the new law charge or the conspiracy charge. They'll run concurrent. You will get credit for all time served. In addition, there are a number of fees and costs. And following the 36 months, it's followed by 2 years of probation. You understand that? 2 years of probation, no contact with the co-defendants, no contact with the victims, random urinalysis, and then fees and costs. You understand? That's all a part of this? Now, I will just tell you, by matter of kind of experience, everybody takes it real seriously, these no contacts. No contacts means it's your obligation to stay away from them. Even if they walked up with you and, hey, and they want to talk to you, you're the one who's going to get in trouble. Stay away from them. Just turn around, walk away. Bump into them in the store, nobody's going to get in trouble if you turn around and leave, okay? But it's your obligation. It's not their obligation. Hey, he got up and he wanted to talk with me. I didn't go up to him. You're the one who's in trouble, okay?
And Judge, since we're revoking and terminating his probation in 20 CF 1322, can we write in the plea form, if it's not there already, to send all the monies to collections? Perfect.
With respect to that VOP cost of collections.
Okay. And the restitution is joint and several with the co-defendants. That means you all owe it the same amount. Whenever it gets paid off, it gets paid off. But that's $59.58. And who is that payable? Just to Jonathan Johnson?
Yes, sir. And I've given probation the victim's information.
Okay. Very good. Thank you very much. Good luck.
Thank you, Judge. That's all I have today.
And Your Honor, whoever requests supervision may be waived due to the amount of restitution.
That is so ordered. Thank you. You have another one?
I have two, Judge. Sorry.
Well, that's all right. I
Roger Lee's
didn't remember I had any extras. Go ahead.
Roger Lee and then Calvin Riley.
This from the arraignment or this morning?
One was from this morning, Calvin Riley, and then one's from this afternoon. Roger Lee is number 18 on the afternoon docket.
Is that the first one we're doing?
Yes, sir. Charles Russell, Public Defender's Office. Judge, this is Roger Lee. Case number is 22 CF 1660. And if I might have a moment. Any questions? On Mr. Lee's case, Judge, we've worked out a plea bargain in exchange for a plea of no contest to the possession of controlled substance, possession of a prescription drug without a prescription. It's going to be an adjudication of guilt, 60 days on each count, concurrent to each other and concurrent to any other sentence. He would pay court costs, $100
Or with
cost.
any other sentence?
He's got a misdemeanor sentence on his criminal traffic case. $150 public defender fee. He'd have 120 days after release to pay, or it goes to collection, and he gets credit for any time served. The state is changing the score sheet slightly. We thought we were going to incorporate a criminal traffic case, but that case has already been resolved, so she's going to move that from additional offenses down to prior record, I guess. I may approach Judge.
Thank you. So I still don't understand we're dealing with two cases, one charge, two counts. Then you're saying concur with any other sentence. I'm just,
That's the criminal traffic offense that he pled with Judge Ward already.
any other prior sentence?
He's,
I just want to make sure we're clear. I'm not clear, but that this document and subsequently the order is clear. That seems to be a little vague, that it's running concurrent with any other sentence that we're not even dealing with.
30 days, correct.
But it's concurrent with the sentence that Judge Ward gave him. The case number for the clerk's information is 22 CT 1251. He was already sentenced in that case by Judge Ward.
Well, I would suggest we just slightly change this wording. I'll let you do it then. And concurrent with the sentence in, boom, give it your case number. And
I
you
can do that, Judge.
Yeah. Just trying to clarify it, so you don't, and last thing I want to do is, you think you're getting credit, some concurrent, and then it's like confusing, you don't get it, you're like, we're writing open court, we said it, and,
Thank you, Your Honor.
we don't, sometimes trying to be clear is
Yes, sir.
most important.
Thank you very much.
Okay, Mr. Lee, would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of the plea agreement.
Yes, sir.
You can put your hand down. So, I just want to make sure, two things, you understand what the plea is, it's free and voluntary.
Yes, sir.
So you heard 60, the core of your plea agreement is the 60 days
Yes, sir.
running concurrent. Both the charges in this running at the same time, as well as another case that you previously had a sentence in
Yes, sir.
county court, 22 CT 1251. So it's running concurrent to all those, okay? And in addition to that, there's some court costs and fees. You'll have 120 days after your release to pay, or it goes to collections. And again, you will get credit for all time served. That's obviously very, very important.
Yes.
So I see you've signed this plea and sentencing agreement. You went over it with your attorney?
Yes, sir.
Had all your questions answered?
Yes, sir.
Okay, you understand that by entering into this plea agreement, it's a final resolution of your case?
Yes,
You're
sir.
done with it, you're finished.
Yes, sir.
And by doing this, you're finishing the case, but you're also waiving the right to go to a trial, and you're waiving
Yes,
right
sir.
basically to object at this point, other than a few kind of technical issues. For the most part, you can't appeal this. You understand that?
Yes, sir.
Very good. Based upon that, the testimony of the court will accept your plea. There'll be an adjudication of guilt on both counts, 60 days in the county jail for each of the two counts in 22 CF 1660. They will run concurrent with each other and concurrent to the sentence in 22 CT 1251. Again, court costs and fees, you get 120 days to pay, or they go to collections.
Thank you, Your Honor.
Good luck, sir.
Thank you.
And then my last case, Judge, is going to be Calvin Riley. He's on your morning docket, number 47. Judge, this is Calvin Riley. Case number is 22 CF 295. We've reached a plea agreement with the state in exchange for a plea of no contest to the charges. On count 1, which is the aggravated assault, it's going to be adjudication withheld. Count 2, which is fleeing and attempting to elude, is going to be an adjudication of guilt as required by statute. Counts 3 through 6 are all misdemeanors, and that's going to be adjudication of guilt. Counts 3 through 6, the misdemeanors again will be time served. Counts 1 and 2, which are the felonies, it will be time served plus 48 months of probation, waive the cost of supervision. He would be assessed court costs, $100 cost of prosecution, $150 public defender fee. The court would reserve on restitution to the Okaloosa County Sheriff's Department for 90 days. Mr. Riley would perform a substance abuse evaluation and complete any recommended treatment. He'd be subject to random urinalysis. He could have no alcohol or drugs without a prescription. He would perform 20 hours of community service. He would testify truthfully against co-defendants. He would have no contact with his co-defendants. He would have his driver's license revoked for 1 year as provided by statute. And also, the court would have no objection to a hardship or business purposes license if qualified, and I just put that in there. Sometimes the DMV wants input from the court. And we have a score sheet, too.
Restitution reserved to the sheriff's office.
Thank you. Hey, Mr. Riley, it's kind of complicated, but I got to go over it with you, okay? Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement. Again, fairly detailed. In addition, those same terms are contained in your plea and sentencing agreement, which I see you've signed at the back here.
Yes, sir.
So have you gone over these terms? Do you feel like you understand them and you've had all your questions answered about these terms?
Yes, sir.
Obviously, the key thing, and I want to make sure I understand this, he's getting credit for time served on actually all the 6 charges. In the 2 felony charges, in addition, he's getting 48 months probation. Is that starting from now or from the arrest? From now?
Start
Okay.
when he's released.
Okay, very good. So additional, so you get a full 48 months.
Yes, sir.
Okay, most important thing, start it, stay in contact with your probation officer.
Yes, sir.
They need to become your best friend. You need to be there if there's some mistake or foul up. You need to have a good lines of communication.
Okay.
And it starts with not having them chase you around, you chase them down.
Yes, sir.
It's a practical matter. Okay? Sir, you're serving your own interest by doing that. You're not being nice to them, you're serving your interest because it'll go easier. We want you to be successful, but 4 years of probation, it's not, I know you're getting out, hey, where do I sign? I'm getting out of jail. But 48 months is a long time. You got to work at it. Okay?
Yes,
You
sir.
willing to do that?
Yes, sir.
And you've had all your questions answered about what probation means and curfew and all that?
Yes, sir.
You're also going to be doing the substance abuse evaluation. You need to start that right away. Okay, don't wait 6 months or a year. You get some support structures around you.
Okay.
A lot of people don't think about it. We all, guys, got to be tough. You got to do everything on your own. It's not life. Not anybody. So, build those professionally, family, build those supports around you where you can be successful, okay?
Yes, sir. Thank you.
So you start with this, though. Start with following through with the probation, because they'll work with you. They'll help you, okay? So, any questions, you have any legal questions about this? About the plea agreement?
No, sir.
And you understand that by entering this plea agreement, importantly, you're waiving a bunch of rights. You're waiving the right to go to a trial, the right to contest this, to force the state to prove their case beyond a reasonable, all that stuff, you're waiving.
Yes, sir.
So you can enter into this, get it resolved, okay? Is that what you want to do?
Yes, sir.
Very good. Based upon that testimony, the court will accept the plea agreement. There will be an adjudication withheld on count 1. Counts 2 through 6, adjudication of guilt. Time served on all the charges, plus first 2 felony charges, 48 months. Probation, as well as the cost and the requirements for community service hours and evaluation, all the things that are contained in the plea agreement. Okay?
Yes, sir.
Very good. Good luck with everything.
Thank you.
And the defense in agreement on the score sheet.
Yes, Your Honor. And now that's it, Judge.
That's it. Mr. Harper, were you holding off, hoping the rain would stop? Is that? There's been a lot of rain up in Crestview lately. It's like one day after another.